Wait 1 second and we'll get started. All right, Ms. Rivers, are you ready? Let's go on the record. This is day 5, excluding jury selection of State versus Parks and Phillips. I have, let's get the defendants out here. That'll be step 1. So you can't get back there right now. Like if Mr. Parks really needed to see you, you couldn't go say hi.
I can get through the door, I just can't open the cell.
Oh, okay. You can get back there. They just can't get out of where they are. You don't have your own key? Do we have an ETA for the key?
She's there right now.
She is the person who took the key, or she's getting a key? Okay. All right. While we're waiting, Mr. Rowe, you are closest. If you would grab, these are hard copies. I only printed 3. So 1 for you, 1 for Mr. Manettis, and then Mr. Porter and Mr. Greiner can share. That's not working well. Is there anything any of the 3 of you wants to discuss, not on the record, because we don't have the defendants here yet? I'll take that as a no, sir. Okay.
I was waiting for the answer.
Okay. The sir part actually wasn't important, but it was the no. Okay. Having a problem with the jury camera. Maybe it will start working again. It locked up. All right, let's get that fixed. Is there like is that connected to something down at someone's feet?
Not feet,
There's something back there. Is there something you can turn off and on? Let's try that because it's being weird. What is back there?
It's a monitor. Connected to the wall. They got it mounted to the wall.
Oh, okay. Does it have any buttons on it?
Yes, it's powered off.
Oh, you powered it off and now it's back on?
Yes.
Okay. Let's retry. You have a key? Yay. Yeah. It's the big one is for the cell?
Yes.
It's funny. It's like out of like the Middle Ages,
Yeah.
which may be the age of the jail cells back then. So there's not one for every deputy or one for every courtroom?
So yesterday we were sharing the sheet.
All right, that worked. Thank you for turning it on and off. Just in time as our defendants entered. Okay, let's get on the record. What now? Okay, that should work. We now have the defendants in the courtroom, State versus Parks and Phillips. It is Wednesday, a little after 1 o'clock. We were missing one juror, number 13. Once he gets here, we should be ready to go. Mr. Greiner, are you prepared to present the state's closing argument this afternoon?
Yes, Your Honor.
Will you or Ms. Porter be opening and closing?
I will be opening and closing.
Okay, so you'll be up first. Mr. Manettis, have you and Mr. Rowe decided how you are dividing up? Not the time, alas, I have to give everyone 2 hours. Please don't use your full 2 hours, spare the jurors, but who's going first?
I think we've agreed that Mr. Rowe will go first, and then I'll go, and I anticipate mine being like 45 to 50 minutes long.
Okay, well within the confines. Mr. Rowe, do you have any concern about being the first of the 2 defense closings?
No, just we get our work.
Great. I appreciate you guys collaborating in that way. So we'll go Greiner, Rowe, Manettis, Greiner/Porter, and that'll get us through it. It would be great if we did all the closings this afternoon. I'm gonna hold the jurors here as late as possible. They cannot stay till 6, they said, but if we can fit all of that in, that may be how we finish today. We may lose a juror today. I think one told us, hey, I got to be somewhere on Thursday. And we foolishly last Wednesday thought that's so far away. Of course, you'll be able to go on that trip and it won't impact your service. But we'll cross that bridge at the end of the day. Mr. Greiner, you feel like you have all the technology primed and ready to go that you'll need for your closing?
Believe so. I will test it one more time.
Okay.
All right.
Whoa, I see a lot of slides.
I go quickly. I go quickly.
All right. So we're just waiting then on the juror number 13. Oh, I'd ask this. I don't know where it is. It may be in that bin. Ms. Porter, if you wouldn't mind, if you won't be doing either of the closings for the state, if you wouldn't mind taking the lead during the closings of getting all the exhibits in numerical order. What has often been a source of delay in getting the case to the jury is exhibits have been moved around as they should be throughout the trial. And then only after I've charged the jury and the jurors are waiting, we realize, oh, let's get everything in order. If you wouldn't mind getting everything in numerical order, then I'll have you all during a break at some point have discussions about whether there's certain things about which there's a disagreement, whether they should go back with the jury or not. That would be very helpful. Thank you. Please. Ignore the fact that it says it's a crime to have that mail bin. Doesn't apply in court.
A lot of them are in order. Yeah.
All right, our last juror just got here. I don't know if that means he's in the, they know the light trick.
He's walking in the door.
Walk, oh, okay, you, did that come over the radio? Okay. Oh, so we're just waiting for the light to go on. What building is he in? Our building. Okay. Why don't you make sure everyone else is ready, so when he makes it, he can just come on in. I did, counsel, look into that question of whether it is mutually exclusive to argue voluntary manslaughter and justification, and it's not. There are some cases that say you can. It's a different level of violent passion you have to experience. It is a higher level for voluntary manslaughter that would make an otherwise illegal killing into voluntary manslaughter than the passion that would incite the instinct for self-defense. But you can argue both, and I should charge both. I don't think there's much there for voluntary manslaughter, because you'd have to be arguing that someone did something that got the defendants riled up as opposed to defensive. But clearly there had been a back and forth between households in that neighborhood. So I kept voluntary manslaughter in. I added accident, and otherwise it's as we discussed. Oh, yeah, I didn't know. I'm sorry. You're waiting on me? Oh, bring him in. Thank you. Judge, we're just sitting here. Please. We were waiting on you. That's awkward.
All right, Judge. Put it in the counter for.
Thank you, Deputy Gordon. Everyone else can be seated. Happy Wednesday.
Thank you.
Thank you for 12 of 13 of you being here on time. But we're good to go. Couple things before we dive into the substance of the afternoon. Number one, I get regular updates from the county equivalent of FEMA about Helene. We're good for today. We ought to be good for tomorrow if we spill over to tomorrow. But we'll monitor that together. You should not assume court is closed. You will get contact from me or my chamber saying don't come in. I think that's late Thursday, early Friday that we need to worry, but it's an evolving situation. In connection with that, you'll see that sign that looks like a tornado or something on that door there. We're actually in one of the safest parts in one of the safest buildings in downtown Atlanta. So your bigger risk would be trying to leave court rather than staying here with us. So once you get in the building, you're in a good space should there be dangerous storm activity. Again, today isn't that day. I don't think tomorrow is that day. I don't know that your service will extend beyond tomorrow, but we're tracking it, not ignoring it. Even though there are no windows here, we're being mindful that there may be some tough weather coming up later this week. What we have for today is closing arguments. The state, because the state has the burden of proof beyond a reasonable doubt, gets to open and close with closing arguments. So Mr. Greiner or Ms. Porter will have a chance to argue to you what they think the evidence has proven. Sit down, and then both attorneys for the defendants will have an opportunity to argue to you what the evidence has not proven. And then the state gets the last word. We call it rebuttal, where they'll get to address some of the things that you may have heard from either Mr. Rowe or Mr. Menettis. Again, the defendants have no burden. It may be that neither defense attorney stands up and gives a closing, but I have it on pretty good information that they both will give closing arguments. Nothing any of these lawyers says to you is evidence. You should feel free to be persuaded. These are smart people who know the law and obviously know the facts of this case. But if an attorney stands in front of you and pounds on a podium respectfully distant from you and says, by golly, the evidence was that 39 shots were fired that day. That doesn't mean there were 39 shots fired. You will decide if any shots were fired that day. But again, it's okay to feel persuaded by what these lawyers say. It's just not the evidence. The evidence is closed. There's no new evidence. You'll get law in a little bit from me, but no new facts that you'll be finding in this case. With that, states part one of closing.
Thank you. And Judge, before we begin, may we just approach very briefly, just very briefly?
Okay, that's what the last 20 minutes were for, but why
Understand, Your
don't you come right over here.
Just determine why you are free to cover anything you want in that space.
Understood. Thank you.
Didn't mean to sow that confusion. Thank you for asking.
Okay. We've all heard the phrase truth and justice for all. trials and investigation into the truth. And later today, when you all go back to discuss the evidence and the testimony in this case, you're going to be talking about it in an effort to get at the truth. Essentially what occurred based on what the evidence has been entered in, what the witnesses said, and all these different things. At the end of these closing arguments, the judge is going to tell you what the law is to be applied, and it's simply a matching of the law and the facts together to render a verdict, again, to speak the truth. So I'm going to use this first part of the closing statement part to talk about the laws. It's a little dry because the law can be a little bit dry, but the judge is going to tell you what the law is, and it all comes from the judge, really. This doesn't happen often, but the judge is going to tell you that you're bound by the instructions and the law that he gives you. And if there is any juror that, for whatever reason, doesn't want to deliberate with the other jurors, just bring that to the court's attention. The judge is going to let you know how to ask questions and do these different things back when you're deliberating over the evidence in the case. The judge is going to tell you that the testimony of a single witness generally is sufficient to establish a fact. Generally, there's no legal requirement of any corroboration as long as you, the jury, deciding together, believe that witness's testimony. The judge is going to give you some instructions on determining credibility of witnesses. These are things that we typically all use in our everyday lives, though. What's the person's manner and means of knowing the facts? How are they testifying? Do they seem to be credible? What's the probability or improbability of what they're saying? Do they have an interest or a lack of interest in the outcome of the case? And lastly, your evaluation of their personal credibility as you observe it. As they testify, how do you all believe that they came across? Do you believe that they were telling the truth or something less than the truth? The judge is going to tell you that the state must prove intent beyond a reasonable doubt. It's one of these concepts that has to be proven to you beyond a reasonable doubt. So the judge is going to tell you that the intention to commit a crime can be inferred from proven circumstances or acts or conduct. We can't read anybody's minds, but we can infer what was in their mind by what they did. What was their conduct? How were they acting? In your discretion, it can also be inferred when it is the natural and necessary consequence of an act. You can infer what they intended to do. If I point a gun and I pull the trigger, you can infer that I'm intending to pull that trigger and send a bullet down range toward a target. But again, you, the jury, are making these different fact determinations on your own as you deliberate back in the jury room. One of the most important concepts in this case is this right here: transferred intent. Talked about a little bit during the opening statement. The judge is going to tell you what the law is. Essentially, if a defendant intentionally commits an unlawful act, and that act harms someone other than who they were intending to harm, that intention to harm the first person transfers onto the second. It's not a defense to say, I wasn't trying to kill Mr. Arnold, I was shooting at that house over there, I didn't mean to kill him. It's called transferred intent. The intent to commit the crime to somebody else transfers onto the actual victim. That's the law. The judge will instruct you on that law. Transferred intent. Another critical legal concept in this case, because we have multiple actors, is party to a crime. Every person, every party to a crime who is charged with, they are a party if they directly commit the crime, if they help in the commission of a crime, or if they advise or encourage another to commit a crime. Classic example typically given in law school classes or whatnot would be a bank robbery. Now, the getaway driver who drives up, never gets out, and never goes in the bank. You have two would-be robbers who go into the bank. One has a gun, one doesn't. The person with the gun ends up killing someone inside. The person who was just gonna grab the money doesn't grab anything and they run out the door. All three of them are parties to the crime and they're all three guilty of murder, including the getaway driver who never went inside the bank, including both people who never had a gun. It's the concept of party to a crime. But again, you have to intentionally help in the commission of a crime, or you have to intentionally advise or encourage another to commit a crime. Conspiracy. Conspiracy is not necessarily, something like the mafia or something like that. Conspiracy is an agreement between two or more people to commit an unlawful act. It's a very important concept in this case, and it doesn't have to be words. You don't have to have an express agreement. You don't have to say, okay, you run here and I'll run there and, you go shoot. It doesn't have to be like that. It can be, a nod. It can be the slightest little thing. It can just be an understanding between two people who know each other. And in this particular case, for example, as soon as one person pulled out the gun and began shooting and others joined in, they're all part of it. Even if someone did not shoot right away, they're all part of it. So G and these two defendants, they're all part of this conspiracy to commit these unlawful acts. This kind of third sentence down is important because any act done by one conspirator to further that conspiracy is legally the act of all conspirators. One person acts, you got an agreement, one person acts, they've set it in motion. And that's what forms a conspiracy. The judge is going to tell you you can consider the presence, companionship, and conduct before and after the commission of the crime and determining the existence of a conspiracy. For example, in this case, they all committed their act together, they all fled together. It's an example, and I will talk a lot more about that a little bit later this afternoon. You can consider what they do before and after in your consideration of the existence of the conspiracy. The judge will tell you that someone who's just merely present, doesn't do anything, just merely present, being on scene, is not to be considered guilty unless the evidence shows beyond a reasonable doubt that defendant committed the crime, helped others do the crime, or was otherwise a party to the crime. We get back to that central concept of being a party to the crime. So you're going to have the indictment back there with you when you begin your deliberations. This is just a copy. I'll talk a little bit about the language of it during the opening statement. This is the language here for count one murder, in that these two defendants, each of them, and when you render your decision, it's going to be based on each one of them as to each of these counts. Okay. So if each of them did unlawfully and with malice aforethought caused the death of Tavius Arnold, a human being, by shooting him with a firearm. Okay. And again, this is where these concepts of party to a crime come in. You don't have to show who's the one who actually fired the fatal bullet. They're all acting as a party to the crime, party to the crimes. They're acting in what we call a conspiracy. Because we've got two or more people. We had three, possibly more, to have this idea. It doesn't have to be an express agreement, a nod, a movement. It could be words. But their actions together, malice aforethought, I'm going to talk about that, caused the death of Mr. Arnold. The judge is going to tell you that to prove malice murder, the state must show that a defendant caused the death of another, either himself or other people. That's the party to a crime part. Unlawfully, in other words, there was no legal justification, and also with malice aforethought. So what is malice aforethought? Here's another kind of running through the elements. Killing must have been done with malice to be murder. Malice is not necessarily ill will or hatred. You don't have to hate somebody. These kids don't have to hate the people in 4215. It's just an unlawful intent. Malice can be found when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another. That's one way. But the second way, you can also find malice when there does not appear to be a significant provocation, like here. Nobody's shooting back at them. There's not a significant provocation, and the circumstances of the killing show an abandoned and malignant heart. An abandoned and malignant heart. Interesting concepts here. When you shoot all those times in a neighborhood with kids, families, people outside, people inside their houses, that is an abandoned and malignant heart. It's an abandoned heart. You don't care. You don't care what happens when you pull the trigger. You just don't care. It doesn't matter. It's an abandoned and malignant heart. That's what this is. And the three of them were acting in conjunction with each other together as parties to a crime, as part of this conspiracy. Don't care what's going to happen. That's an abandoned and malignant heart. That's what that means. The circumstances show that. There's no significant provocation. We'll talk more about that, because it would have to be a significant provocation to a reasonable person. In absence of that, the circumstances show this abandoned and malignant heart just doesn't matter. You're going to just do ill will, it doesn't matter. The judge is going to tell you that the state does not require premeditation to prove murder. If a killing is done with malice, it's murder regardless of how briefly the malicious intent existed. It can just be formed like that, just so quick, just don't care, you shoot with malice. That's malice murder. No specific length of time is required for malice to arise in the defendant's mind. And again, we don't have to read somebody's mind. We can just look at what they're doing. And you, the jury, can reasonably put together, here are the facts, here are the circumstances of the case. And it makes sense that the actions show this malice, this malicious intent. If malice was in the defendant's mind at the time of the act of killing and moved the defendant to do it, that is enough for the killing to constitute murder. The judge is going to tell you that proof of motive is not necessary. It's not essential to the crime of murder. If there is any evidence of motive, it's just here to help you determine whether it helps establish the defendant's state of mind at the time of killing. So in movies and TV, we see these stories that have been created by Hollywood, and they always look for a motive. What's the motive? Why was this murder? Why didn't it occur? The reason why it's not essential to prove is because in the real world, not some TV show or movie, in the real world, murder never really makes sense. Almost never makes sense. People killing each other over a bag of drugs, it doesn't make sense. You get mad in a relationship, you shoot your wife, it doesn't really rise to the level of what it should be. And that's the case here. We're never going to understand this, because it's never going to really make sense to just shoot all these times in a neighborhood. That goes back to that abandoned malignant heart. You just don't care what you do. Don't care what the circumstances, what happens. It just doesn't matter. There are two counts on the indictment, counts 2 and 3, that have to do with felony murder. It's a little different from malice murder. Felony murder, for count 2, for example, we have to show that the defendants caused the death of another person, again, either together or jointly with each other, by committing a felony. And aggravated assault is a felony in Georgia. There were 31 aggravated assaults here in this case. Every time someone fired a gun, that's an aggravated assault, because they're using a deadly weapon handgun, and they're trying to assault or create fear or attack in some way. Bottom line is very important. The state does not have to show that these defendants acted with malice, that abandoned and malignant heart I talked about a minute ago. We don't have to show that for felony murder. We just need to show that they caused the death of another while committing a felony. Aggravated assault is a felony. And that's why count 2, felony murder, says that each defendant did unlawfully endure the commission of a felony to wit aggravated assault with deadly weapon, caused the death of Thaddeus Arnold, a human being, by shooting him with a firearm. Again, transferred intent. You don't have to try to shoot him. He's not the target. Trying to shoot over there, wherever. He's in the way. He gets hit. Committing that aggravated assault, deadly weapon, and it kills someone. The intent to commit that aggravated assault against somebody else, shoots our deceased victim, and he's dead. That's felony murder. Count 3 has to do with a different charge of felony murder. It's still felony murder. We have to prove that the defendant caused the death of another person by committing a felony. And this time, on count 3, it's criminal damage to property. Criminal damage to property in the first degree, which is what's alleged here, has to do with interfering with property, shooting at a house, and you're endangering the life or lives in this case. What was it, 8 people, 9 people in the house, 4215, and then other people, other houses too. Shooting somebody's house, that's criminal damage to property. If by doing so you cause somebody's death, they don't have to be inside that house or shooting it anywhere. That's felony murder based upon criminal damage to property. That's why count 3 reads this way. Did during the commission of a felony, criminal damage to property in the first degree, cause the death of Thaddeus Arnold, human being, by shooting him with a firearm. Again, not trying to shoot Thaddeus Arnold, trying to shoot something else, but you hit Thaddeus. And that's felony murder. So the judge is going to instruct you that you can find the defendant guilty, each one of them, both of them, guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon, regardless of whether he intended the death to occur. And the same for criminal damage to property, regardless of whether they intend a death to occur. When you shoot in a house, I don't really intend to kill anybody, but I do it. Somebody dies, it's felony murder based on aggravated assault, or felony murder based on criminal damage to property. The judge is going to tell you there's got to be some causal connection between a felony and a death. Felony murder is established just because there's a death that occurred at the same time or shortly after the felony was committed. Felony's got to directly cause or play a substantial and necessary part in causing death, regardless of when the death ultimately occurred. So, classic example is like a tax attorney who, has a client who's been, cheating on their taxes, and the tax attorney starts looking at things and gets so upset and dies of a heart attack. Okay, well, the client's felony tax evasion, that's a felony, but it didn't really cause the death. It's not really a foreseeable result. But in this case, we got gunshots going all around the neighborhood, 31 times. Gunshots. It's foreseeable. It's directly foreseeable that there will be a causal connection between shooting a gun and killing someone. The judge is also going to tell you about a concept that you can consider it as it's like a lesser included offense, voluntary manslaughter. If you cause the death of another person that would otherwise be murder, but if it's the result of sudden violence, irresistible passion that comes from serious provocation, and there would be such to incite such passion in a reasonable person. Really doesn't apply to this case. I think my colleagues on the defense team might argue this, but it really does not apply in this case because there's no real serious provocation that's going to excite someone to act in the manner that they acted in a reasonable There's no reasonable person who's just gonna start shooting up the street because they saw somebody out there and they didn't like or they were concerned about. A more reasonable act for a reasonable person would be to call 911. The police are there very soon. You got a concern, you take that action, not just start shooting. So voluntary manslaughter does not apply to this case, but you may hear argument in favor of that. So count 4 is our aggravated assault charge. You see it on the indictment. It really relates to count 2. So remember, count 2 is the felony murder charge based upon aggravated assault. This is what we call the predicate or underlying offense of aggravated assault. So this is very simply that each defendant did unlawfully commit an assault upon the person of Patty's arm by shooting him with a firearm, the same being a deadly weapon. Well, we know a firearm's a deadly weapon. It certainly caused death in this case. And we know that Tabby's arm was the one who was shot. And again, this transferred intent, that concept of transferred intent, transferred trying to assault somebody else, but actually you shoot someone different from your intended target, it's still aggravated assault with deadly weapon because of the concept, legal concept of transferred intent. So the judge will tell you specifically that a person commits an assault when he attempts to commit a violent injury to another, shooting a handgun up the street at a house or a car or whatever. That is attempting to commit a violent injury to someone else. The judge will tell you that under the law, if a person commits an aggravated assault and assaults another with a deadly weapon, then a firearm is considered a deadly weapon. Count 5, criminal damage to property in the first degree. This is that shooting at the house count. This relates to count 3, felony murder. This is the predicate offense for count 3, felony murder. And so specifically what it alleges and we've proved is that the defendants did unlawfully, knowingly, and without authority interfere in the townhome residential dwelling located at 4215 Notting Hill Drive, City of Atlanta, property of Tabitha Hammond, you heard her testify, in a manner so as to endanger human life by shooting into it with a firearm. Classic case of criminal damage to property in the first degree. It's what it is, it's what happened here in this case. So specifically, the judge will tell you that a person who commits the offense of criminal damage to property when he knowingly and without authority interferes with the property alleged in the indictment in a manner so as to endanger human life. You shoot at a house, you're endangering human life. You don't have to be shooting at a window, you can be shooting at a wall, doesn't matter, you're endangering human life. The last count on this indictment for you all's consideration is count 6, possession of a firearm during the commission of a felony. So, as I stated during my opening statement, having a firearm in possession while you commit a felony is its own separate offense in Georgia. People want tough laws against gun violence. Here's one of them, right? If you have on your person or within arm's reach of your person handgun during the commission of a felony, and there are several named here, then that is its own separate offense. This is, you can have something else in your possession, a slingshot, a bow and arrow, or something else. This is a deadly weapon, but just a specific offense for owning a firearm or having a firearm on your person in your arm's reach while you commit the offense of murder, felony murder, aggravated assault with a deadly weapon, and or criminal damage to property in the first degree. That's count 6. And the judge will tell you this, specifically the statements prove that the defendant had a firearm within arm's reach of his person while committing a felony against or involving the person of another, murder, felony murder, aggravated assault with a deadly weapon, criminal damage to property or felonies, and a firearm used in handgun. So the law, the indictment tracks the law pretty well. So those are the things that the state has to prove beyond a reasonable doubt on the indictment. And the defense has raised an affirmative that, you know, the act was committed, but there are circumstances that justify. They claim of self-defense, so sometimes. Once this defense is raised, the state must disprove it beyond reasonable doubt. And we've done that through the witnesses themselves and through the evidence and through cross-examination in different ways, the videos, and a little bit more I'll discuss later. The judge is going to tell you that a defendant is justified in using force that is intended or likely to cause death or serious bodily injury when he reasonably believes that the use of such force is necessary to prevent death or serious bodily injury to himself or a person. So, reasonably believes is underlined because who decides that? You all, the jury decides whether it's reasonable. When you all go back to talk about the evidence in this case, you're going to be doing so in a determination of whether these two acted reasonably under the circumstances. Judge is going to tell you that for the use of force to be justified, the defendant must believe that the threat, the use of force is necessary, the belief must be reasonable. A reasonable person, you all deciding what's reasonable, you the jury, what a reasonable person would also believe the threat or use of force is necessary. In other words, it's not the Parks definition of what's reasonable or the Phillips definition of what's reasonable. It's not what they want to come up with. It's what you all sitting as a jury decide is reasonable given the circumstances. And the judge will instruct you that reasonable belief, to find that, must be what prompts him to threaten or use force. Another part of the law the judge is going to instruct you on says that a defendant is not justified in threatening or using force. If they wrote the threat, you know, they started committing a felony, such as aggravated assault, criminal damage to property, or possession of a firearm during the commission of a felony. As I mentioned, the standard of a reasonable person is related to defense of reasonable fears in the trial for murder is one which the jury must determine from their own observation and common knowledge and experience. That's why you all are on the jury, you're reasonable people, and you're here to determine whether these two defendants acted reasonably given the circumstances. The judge is going to tell you that the state must prove the case beyond reasonable doubt. And he's going to tell you what that is. Part of the instruction is going to be that reasonable doubt is based on a fair and impartial jury honestly seeking the truth. It's not a vague or arbitrary doubt, but a doubt for which a reason can be given. And he's going to tell you that you don't have to prove the case beyond all doubt or for mathematical certainty. That means just what it says. When the case has been proven to you beyond a reasonable doubt. You're not here to seek doubt or look for doubt. You're here to consider the evidence in and of itself and determine whether it's been proven to you beyond reasonable doubt the elements of the crimes that have been alleged in the indictment. So what's inside this circle is what the jury is to consider. The elements of the crime. The elements of the crime are contained on this indictment. So it's really a matching of the facts, and the evidence that you've heard here in this case, matching that up with what's on the indictment. And whether or not the elements of the crime have been proven to you by the different witnesses that have come in and testified in the evidence. What's the credibility of these witnesses? What is the defense? What's your common sense? What does your common sense tell you? Your life experiences. What are the photos and the documents telling you? You've heard expert testimony in this case. What did you learn from the experts? You're to consider things like the defendant's fleeing after the crimes were committed. What's the law? What did the defendants do in and of themselves out there that day and then before, during, and after? And also, what was the testimony? These are the things to consider. Specifically, the judge is going to tell you, you're not to consider things that are outside this circle, like sympathy for these defendants, or whether you disagree with the law. During jury selection, there were a number of questions asked about, about just that. If you hear a law and you don't really agree with it, you still be a fair and impartial juror. That's what we're talking about. Outside the circle are also things like conjecture. Well, I wonder if such and such, or what's the possible penalty, or prejudice, or sentiment, or dislike the police, or these guys' agents, or public opinion, or passion. Those are things not to consider. What the jury is to consider are the things that are inside the circumstance. There's been a number of witnesses in this case over the past week. It's not a memory contest. Everybody brings their own memory of what occurred in the courtroom. They're trying their best. Of course, there will be inconsistencies in their testimony, but many of the main points of testimony are consistent. And we do have video, and we have other types of evidence in this case, which helps you decide and determine what actually occurred in this case. The judge is going to tell you later that there's a difference between direct evidence and circumstantial evidence, but you all, the jury, decides how much weight you want to give to direct evidence or to circumstantial evidence. Typical example that's often used is when you go fill up your car with gas. You might drive up and you get out. Your gas gauge in your car is indicating it's empty. You get out, you put your credit card in the machine, and the numbers, calibrate. You pull out the nozzle, you put it in your car, and you pull, and you might see some numbers change on the pump. You might, feel a little vibration. You may smell gas sometimes. And then there's a click, and it's done. Your gas tank is full, right? You pull the nozzle out, you put it in, you get your receipt, and you drive away, and your gas gauge has moved. It would not be reasonable to go in with a receipt and say, you know what, I didn't get gas in the car. You see, you didn't actually see the gas go in the car. But your circumstances tell you that you actually fill your tank with gas. Those are the gas gauge moving, the different numbers on the pump, the fact that you've always gotten gas there and it always works. So we use these concepts in our everyday life quite frequently. Another example, you might go and you might buy a box of cereal, buy some Cheerios, and you have no real reasonable doubt that what you're actually buying is Cheerios. You don't have to open the box, tear it open and look inside, or crack open the top of a Coke and sip it and make sure that that's what you're actually buying. It looks like it. You've always been able to buy it before. We rely on these things in our everyday life. We rely on the circumstances to tell us. And when you all go back to deliberate over the case, you're going to be relying on those everyday experiences that you have when you're sifting through the direct evidence, which is what people saw or they heard or sensed. And the circumstances surrounding it. Again, in an effort to get at the truth in this case. That is your goal, is ultimately to determine what happened based on the evidence in the case. So I'm going to sit down. That's the dry legal part. And my colleagues from the defense team are going to give their closing statements, and I'll be back up a little bit later on this afternoon. Thank you.
Thank you, Mr. Greiner. If you would stop the share screen, whoever's operating that. We're going to now hear, I believe, from Mr. Rowe, and then we'll take your pulse about whether you want to break. But we're going to at least get through Mr. Rowe, and then we'll see how everyone is doing. Okay? Mr. Rowe, when you're ready.
Thank you, Judge. I said in the opening statement that things are not always what they seem, depending on where you're sitting or where you're standing. This case, on behalf of my client, again, we want to say thank you for your civic duty for this week that you have sat with us, that you have sacrificed your time and schedule, your work schedule, home schedule. Thank you so much on behalf of my client, Mr. Parks. And just to kind of review, we know what the burden is in this case. We know what the legal burdens are. My client comes into this courtroom wrapped, dipped, and clothed in a presumption of innocence. He wears that cloth through the entire trial. Unless the state is able to prove beyond a reasonable doubt each and every element of the crime as indicated in the indictment. That's their burden. The judge is gonna charge you that that's their burden. We submit to you today that my client still sits here today with that presumption because the state has not met its burden. Let's look at the state's case and see where the state does not meet those burdens. The first witness, and we're gonna focus more on the lay witnesses because the lay witnesses are the individuals that were actually present in the time of the incident. That's very important. And so the first witness is Tabitha Hammond. Tabitha Hammond. She testified that Sam comes out of her house with 2 guns. He comes out the house with 2 guns, goes to his car, and if you look at State's Exhibit number 16, while he's at his car with 2 loaded guns, a white van comes into the subdivision, a white van. The white van does not keep driving. The white van stops right beside Sam's car. And there's a conversation. State Exhibit 16 sees the white, the white van that the Detective Thorpe said was not involved in the shooting. You know the white van that the prosecutor kept saying not involved in the shooting? But this white van stops right there, beside Sam's car. There's a conversation. Sam got 2 guns. So Sam has 2 guns, and so Carrie Henderson, who's on the video, is alarmed. Not only is Carrie Henderson alarmed, but Lakira Dixon is alarmed. They are so alarmed because of the prior shootings. They said we better pull out our phones because this guy is getting ready to start shooting us. So that's why you see on surveillance camera. Here is Carrie Henderson. I'm gonna catch it. And remember what was said through the state's witnesses. She said, "I got you now." That's what was already into evidence. I got you on camera now. You're not going to get away with shooting up this neighborhood again. I got you now. Right after she says, "I got you now," Sam and an unidentified female gets into the white vehicle and they drive away. Here's the issue. The white van goes down the street after talking to Sam, laying in wait. Minutes later, while the white van is still down the street, shots are fired at my client's house. Now my client is walking down the street to his house. He goes inside of his house to change his pants. All the witnesses says that. While he's inside the house, shots ring out. They ring out. All the witnesses, even the state's witnesses, even Ms. Neal says that there were initial shots. She admitted on cross-examination that when she gave her statement to Detective Thorpe that she believed that Woe and Hawk were the targets of the shooting. She said that. She said, "Yeah, I think." And then she went even further. She said, on direct and cross, all of this is Carrie Henderson's fault because she went out there with that phone, took a picture of that man with that gun, upset him, and they got mad and started shooting up the house, and that's what started this whole thing. That was the state's witness. I didn't put on the stand, the state did. And she said that as a result of the gunfire, my client returned fire. That's self-defense. The kids that were outside, evidence have shown through the witnesses that the kids were 9, 10 years old. His nieces, his nephews outside. So he fired to protect his kids that he was related to. His mother was there, his sister was there. He was firing to protect them. He has a right to defend himself. And he has a right to defend his family. And remember now, the victim is somebody he called Unc. And Miss Neal is somebody like a mother to him. So now he comes outside, changes his pants, Unc falls down, children are running everywhere, gunshots are ringing out. He got a gun in his hand, he shoots back. He seen one of his own team members go down. He's shooting back. Why? So they can stop shooting. And we don't know how many times, he didn't know how many times the guy or whoever was gonna keep shooting. It's not like he's gonna announce, oh, by the way, this is my last shot. No, you keep shooting until he stops shooting. Because kids are outside, your mother's outside, your sister's outside. But the state would have you to believe a story that really don't make no sense. We selected you because we wanted you to bring your life experiences to this courtroom. Your life experiences. Don't leave that at the door. What sense does it make for you to go to your house, initiate a shooting with kids related to you in your driveway? What sense does that make? That story don't make sense. But what does make sense is that if you're at your house and gunfire is coming at you, then you're returning fire to protect the kids, your loved ones. Now that's what makes sense. Which story makes sense? That's the story that makes sense because that's the truth. And the white van is State Exhibit 16. The white van is in State Exhibit 21, speeding away right after the shots are fired. But Detective Thorpe says, they ain't got nothing to do with it. They ain't have nothing to do with the crime scene. Nothing to do with it, nothing to do with it. How do you know? You never stopped the van, you never ran the tag, you never searched the van, you never interviewed the driver in the van. What kind of investigation is that? And look, where's Sam? Why he was not on the witness stand? Why didn't bring him in court? Seems like at least, even if you don't think he's a suspect, seems like he could be a witness. And you say the white van is not involved, but at least they could be a witness. They did not do a thorough investigation. And you know why they didn't do a thorough investigation? Because they got their suspects, the usual suspects. We got them. No, let's not look at the white van. Let's not look at Sam. We'll just do a gun residue test on Jarvis, Harris. But we're not gonna do a gun residue test on Sam, even though you got witnesses saying that Sam was shooting. No gun residue test on Sam. Let's not even talk to Sam. That's not a good investigation. That's not thorough. Somebody was killed. This is not a speeding ticket. You check everywhere you can go. You don't find suspects and then put the facts together to get them convicted. You do what you hear on TV all the time. I know this TV, but you do this. You let the facts lead you to the truth. You don't pick the suspects and then put a case together and say, we threw the case closed. And the reason why you don't want to say the van was involved, the reason you don't want to say Sam was involved, means you have not caught the real killer. You have not caught the person that really is responsible for the death of this unfortunate victim. Next testimony with Mr. Harris. Javante Harris. He just again established that Sam came out there with those two guns, and then shortly thereafter there was gunfire. Next state's witness is Ms. Stallworth. She verified that there was a white van that sped away. The white van that they say were not involved, but ironically stopped to talk to Mr. Sam and ironically sped away. Next state's witness is, of course, Ms. Neal. Now, Ms. Neal, like I said, have established a couple of things. She's establishing that, hey, whoa, I hear myself.
You're good. Yeah, that was, whoa. We're trying to reconnect the camera and the audio came on, but you're good. I apologize for that distraction.
That's all right. Being the commercial break, that was it. Whoa, and she said, whoa and hot were targets, indicating that they were targets of the original shooter. And remember, one of the cameras it's not working. It's not working. But you can't build a case of surveillance cameras and ignore the witnesses. You can't do that. You got to listen to the witnesses. And that are points of view. It's like when you're driving and you look in the rear view, there's something called a blind spot that you do not see until you turn your head. Those cameras have blind spots, especially if there's one set that's not even working. The initial shooters are not on the camera. Well, they're on the camera, but they're not on that shooting. But all the witnesses say there were initial shooters. That's the only way. Young people always say, make it make sense. That's what makes sense. It makes sense. If we're at our house, if my client is at his house, coming in to change clothes, the only way it makes sense is that if somebody was shooting at them first, combined with the witnesses saying that somebody was shooting at them first. Next witness is, I mentioned Detective Thorpe. And I know he want to close his case. He got two guys that were shooting. He got a person that's dead. He got two guys that's shooting. He don't want to entertain. Maybe there was another person that was shooting. You don't want to, it's more convenient for him to have these two young men charged. That way he don't gotta look for the van. He don't have to go look for Sam. And then the last state witness is Jay Jarvis, which nice witness. But I do have a bone to pick with this witness. He indicated that there were at least 3 guns used in the shooting itself, based on the grouping of the cartridges. So We understand that point. But within the grouping of the cartridges, he said there were different brands that's coming from the same gun. I take issue with that. Couple reasons. His lab is not licensed. His lab is not accredited. When he was with the GBI, he was required to do mandatory training, annual training, according to his testimony. He has since been retired for 15 years, not required to do any type of mandatory training at all. Did not indicate he did the mandatory training. Acknowledged that his laboratory is not accredited or licensed. I like Uber, but if an Uber driver come up with no license, I'm not getting in the car. It's not licensed or accredited. So the conclusion that there are different brands coming from the same gun, I would say that you have to be jurors that are responsible to examine the credibility of all the witnesses. And with that being said, we submit for you to consider that there was more than 3 guns, because he admitted on his examination that there were cartridges in the same group, but with different brands, but coming from the same gun. So we say that it may be more than 3 guns. I want to also share with you our witnesses, my witness, which is Ms. Dixon. And again, she shared with you that along with several state witnesses, that there was an initial shooter, and she saw that she thought the guns was coming from up the street, another area. Some said another part of it. And then someone testified that it was in an area maybe where the camera was not working. And then Mr. Phillips testified again about the white minivan that sped off, about the initial gunfight that took place. He testified that my client again was inside the house when the shooting took place. Now, I want to share with you, and I'm getting ready, and I'll be finishing in a minute. I want to go over the indictment. The state has gone over the indictment. I want to go over the indictment at this time. I want to talk about count 1. Count 1 says on the 13th of September, 2021, that my client did unlawfully with malice after thought caused the death of Tobias Arnold, a human being, by shooting him with a firearm, concentration laws of the said state in good order, peace, and dignity thereof. But I want to share with you what my colleague pointed out, something called self-defense and justification and defense of others. I want to share with you what we expect the judge to charge you with. It says sometimes a defendant's use of force is legally justified, so it's not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury only when, number 1, he believes that the use of such force is necessary. Number 2, to prevent death or serious bodily injury to himself or a third person. And number 3, a reasonable person would also find the use of force to be necessary. The state, once we raise, and we did raise it, and we're raising it now, and we raise it with evidence. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide that the defendant's actions was justified, then it would be your duty to find the defendant not guilty. If you believe, and you find, which we believe we have established, that when Mr. Parks came out that house, those 3 gunfires, those gunshots went towards him, and he fired to protect himself or the others that was out there, and he kept shooting, so, because he didn't know how many more times this person was gonna keep shooting at him, then it is your job under the law to acquit him. If you believe that that was reasonable, you believe that force was necessary, then it would be your duty to acquit him, because self-defense is a complete defense to malice murder. It is. Here's the second count. The second count deals with felony murder. And what that says is that in the county of Fulton, the state of Georgia, 13th day of September 2021, that Mr. Parks did unlawfully during the commission of the felony to wit aggravated assault with a deadly weapon, caused the death of Tobias Arnold, a human being, by shooting him with a firearm. Now, the state has not even proven that my client has caused the death of the victim. State has not even proven that. And we would submit to you that he has a complete defense to the aggravated assault with the deadly weapon, and that defense is self-defense. He was being fired upon. He fired and returned fire to protect himself. Deadly force went towards him. He retaliated, he returned fire, which is deadly force. And that is within his right to do that. He has a right to defend he was at his house. And the kids outside were related to him. He has a right to protect his family when he's been shot upon 3 different times. Not like somebody shot one time, like New Year's Eve. This was 3 shots. And you heard it on the surveillance, back to back. So he cannot be found guilty of count 2 if he's exercising self-defense. Here's count 3. Count 3 says that in the county of Fulton, state of Georgia, on 13th day of September 2021, that he did unlawfully during the commission of felony to wit criminal damage to property in the 1st degree, cause the death of Tobias Arnold, a human being, by shooting at him with a firearm. Okay, so we would submit to you that there has not been any proof that during the commission of the homicide of Mr. Tobias Arnold, that my client was committing criminal damage to property. There's not been any evidence. Count 4. It says this: for said accused, the county of Fulton, the state of Georgia, on 13th day of September 2021, did unlawfully commit assault on a person of Tobias Arnold by shooting him with a firearm the same deadly. Well, first of all, the state has not proven that he has even shot Tobias Arnold. And then if the state is saying, well, he shot bullets in that area, it's self-defense. Self-defense. He has a right to defend himself. It's a complete defense to aggravated assault. So with that being said, that's not guilty on count 4. Count 5. Kamaris Parks, for said accused, county of Fulton, state of Georgia, on 13th day of September 2021, did unlawfully, knowingly, without authority, interfere with the town home residential dwelling located at 1415 Notting Hill Drive, City of Atlanta, property of Captain Hammond. Here's the problem with that. There's no evidence, there's no witness that said that they saw him actually shooting, not from his gun, that actually landed at this property. The state was focused so much on that part of the case regarding the homicide, they didn't provide enough evidence as to whether or not my client was actually shooting and a bullet from his gun actually landed in the house of Ms. Hammond. There has not been any evidence to suggest that his bullet landed in a house that had been shot up multiple times prior to this shooting. They have to prove that. We don't have to prove that. We don't have to prove he's innocent of that. They have to prove that beyond a reasonable doubt. beyond a reasonable doubt that he shot a gun and the bullet went into the house of Miss Hammond. They have to prove that beyond a reasonable doubt, each and every element. They have to prove that. Okay, here's count 6. On 13th day of September 2021, did unlawfully have on within arm's reach of accused person a handgun. Okay, that's true. During the commission of at least one of the felonies, murder, self-defense, so that's not that. Felony murder, self-defense, aggravated assault, self-defense. Criminal damage has not been proven. That's not guilty on count 6. This was a very unfortunate incident. But who is ultimately responsible for the death of Mr. Hall? Who is ultimately, who set all these things into motion? And it's not Mr. Parks. He was just defending himself. He was just defending the children that was outside that hugged him on the tape that you saw, on the surveillance camera. Justice is not justice if you don't have the right person. You have the crime, but it's not justice until you have secured the right person that committed the act. Because the minute you convict the wrong person, that's not justice, that's a miscarriage of justice. And what I submit to you today, let's speak justice, let's not miscarriage the justice. We ask that you look at this indictment, look at the evidence and the lack thereof, and come back with a verdict that speaks justice. Not guilty on count 1, not guilty on count 2, not guilty on count 3, not guilty on count 4, not guilty on count 5, and not guilty on count 6. Thank you.
Thank you, Mr. Rowe. So we've only been going for about an hour. I'm fine having Mr. Monetis get up, but I won't interrupt him for a break. We'll hear his closing, which he's forecast will be a little less than an hour, but he's not bound by that. It could go longer than that, just his forecast. Do you all want to take a quick break now, just to stretch? Let me ask this. Is there anyone who needs, because it just takes one. Anyone need a break now? Yep. Okay, that's all it takes. All right, we're gonna keep it to about 5 minutes. I'm actually not letting anyone else go. You guys go into the jury room hallway. We'll get you back in here in a second.
All right, good.
All right, Mr. Griner, anything before we take a quick break?
No, Your Honor.
Mr. Monetis, you'll be ready to go when we bring the jurors back in?
Yes, Judge, I just want to go to the bathroom.
I'm gonna let you do that, but you'll have your version of the technology set up.
Yeah, I'll do that now.
Great. Mr. Rowe, anything before we break?
No, Judge.
All right, I'll see everyone in 3 or 4 minutes. Oh. Least favorite jury selection and that.
Yeah.
Least favorite part.
See, I like challenges. It works.
Oh, for you, that would have to be with all the different voices and everything. Do you take down the charge? Okay.
Those are our favorites, like in school.
Yeah. We've got everyone. Mr. Monetis, you ready for the jury?
Yes, Your Honor.
Mr. Griner?
Yes, Ron.
Mr. Rowe? Good. Let's bring him in, please. So you'll be connecting all these dots with your closing?
No, I can't.
That's the reasonable doubt.
Quad investigation. I think I must have-
Motion adjourned.
Mr. President of the council.
Thank you, Deputy Gordon. You all can be seated. So ladies and gentlemen, we are now turning to, where's we over here? The closing on behalf of Mr. Phillips. Mr. Monetis, when you're ready.
Thank you, Your Honor. Good afternoon, everyone. Well, we're here at the end of the journey, and I think what we expected the evidence to show is what the evidence showed, and then some. And what the state promised, what the state expected the evidence to show, hasn't even come close. What's also true, and it's why we have the burden of proof, it's why we have the presumption of innocence, it's why we have this process and these rules from Mr. Phillips, for all of us, and whoever sits in that chair, whether it's a peasant or a president, it doesn't matter. It's these dots. We have unknowns. All these unknowns. These dots that we'll never be able to connect. Terrible for Mr. Phillips and Mr. Arnold. You know, our society's still working on how to solve these problems of violence, fogging the police misconduct, bias, prejudice, but we do know how to solve wrongful conviction through this process in your service. So it was like we talked about. It was a good day. It was a good day. Mr. Arnold there with his girlfriend. Mr. Hart's there with his mom in his mom's house. Mr. Phillips going over there, sharing the news of having a new baby, not there to take a life or be part of taking a life or have his life threatened or help anyone take a life, but because he had just created a life. So it was a good day on the left, until it wasn't. And while we can never find who's really responsible for this, and it's terrible what happened to Mr. Arnold, I believe that now it's a good day again. Because we have this process, we have these rules, we have this evidence. So what happened is that some person or persons seem to attack that area. And then Mr. Phillips tries to report on his phone if we heard actual testimony about other people doing that, other innocent people doing it. Innocent people like Mr. Phillips, that's something that we can presume is being talked about by Ms. Henderson, by Ms. Lennox, Ms. Maddox, sorry. So that's a natural impulse. It's also a natural impulse for people of Mr. Phillips' age. I think maybe the state and the police don't get that age gap as well, how attached we are to our phones, how much we record things, how much violence we're around, how much violence children are. I don't think any of us can cast the first stone at Mr. Phillips, given his age and given his environment, that he reacted odd, or he should have done this, or he should have done that. He's been living in violence his entire life. Violence used to be less of a norm. Columbine happened, and we talked about it for months. Now things worse than that happen every day, and we talk about it for 5 minutes. And that's the world that Mr. Phillips lives in. The neighborhood that Mr. Phillips lives in, full of violence, full of people like the people that attacked him and the people in that driveway. They did not like the state or the police or other people or us, I don't know, to have guns drawn on you by somebody, to see a man draw a gun on your mom, to see the police draw a gun on you or your friends, just normal, sadly. And there's no normal response to an abnormal situation. And that's what Mr. Phillips was thrown into through no fault or planning or blame of his own. So this is what I think are some 3 key issues of how we ended up here with this wrongful allegation. There's power, presumptions, and persistence. It's about who has the power and who doesn't have the power to make decisions. Those decisions were made on presumptions that were not true. They should have been made on the presumption of innocence, like we're gonna decide here. Like Mr. Parks' attorney said, I completely agree. When you're an investigator, you don't throw a dart at a target and then go and circle the dart and say, oh, I got bullseye. And that's what they did. That's what Detective Ford did. And then he persists. And that he persists in the name of that power because that's what he works for, that's what he serves. Okay? You can't ignore the class issues in the case, the poverty issues, the racial issues. You can't ignore them. And you will see too, it's not necessarily just about race, that's the tip of the iceberg. It's about who do you serve. And everyone here served the power of the system, the presumptions of non-innocence, and then they persisted, and you saw it in front of our eyes. To an extent that I couldn't have even predicted how much they would persist, like gaslighting, like this is how it is. You know, we're seeing that sign, hearing that sign, they persist. So what happens? This is all that we know beyond a reasonable doubt. That G and Mr. Parks react to the attack. I agree. They react in a way that's justified. They react in a way that's allowed under the law, given all the evidence and the testimony. And given that, I'm going to talk a lot about the truth of Mr. Phillips's experience, what he did and what the evidence shows, and the doubt and the state's theory about him. But in a lot of ways, we're not even going to get to that decision. Because I believe Mr. Rowe was right about so many things. And I'm not Mr. Parks' attorney, but I don't think the state met its burden, that Mr. Parks was not defending himself. That's what the judge will instruct. This honorable court will instruct you that you don't have to prove innocence or self-defense. You could have sat there in your regular clothes with no attorney and just twiddle your thumbs and still claim self-defense when there's evidence of self-defense. At that point, again, burdens are only on the state for a reason I'll get into. The state would have to prove that it wasn't self-defense. And how can they do that here? How can they do that? They can't. They can't meet their burden. They can't put a square peg in a round hole. They can persist all they want. We have a process to check on that. We have your service to check on that. You've been qualified to check on that and vote for yourselves. They can't tell you how to think. I can't tell you how to think. No one can tell you how to vote. You can't even tell each other how to vote. We have 12 equal participants qualified in a difficult but really important process to hold the state to its burden that Mr. Parks and Mr. G or anyone else was not defending himself. And so whether or not there's a phone in Mr. Phillips's hands, the state has not met their burden, that even if it wasn't, that he's not innocent. But I'm his advocate. He shared with me what happened. I looked at the evidence. I didn't call him goofy. I didn't question him. And I especially don't question him now with the evidence that came out. Mr. Parks shoots back while he's moving around the driveway. You'll see that in the video. He's moving around different parts of the driveway that later gets contaminated. G shoots back. He's also moving all around there. It's a little choppy and pixelated, but you see G in the all black. You can't see, obviously, it's gun jams. That's an example I'll get to. Detective Ford just trying to persist. And so they're moving all around there shooting. We don't see exactly what's going on, but we're shooting. And we see from Miss Nell, that her perception is that Mr. Parks' bullet goes into Mr. Arnold and kills him. And we can't even necessarily know that. We also heard someone say, I can't remember, that he turned around right before he was shot towards the house, which would be where everyone's saying that 3 shots came from, to the left side of his neck. And that's what happens. He's shot in the neck and he dies. Now, I'll continue you too, that's one of the power issues that's in the case. Sadly, now you have the power to hold the state accountable. Now you have a way to have a consequence on our own government, which is how it's supposed to be. The power is coming from the people, not the police. But at the time, nobody has that power. Nobody, I hate to say this, but people, when you see what happened, no matter what race you are or whatever, as a detective, nobody cared that what happened to Mr. Arnold. They only cared to persist. It really feels like they do not even care that they got the right person or not. They just closed the case, they got a conviction, patted themselves on the back. They think they did it the right way. I don't doubt that Detective Thorpe has, for the sake of all of us that I think before, caught violent people, held them accountable so they can't hurt us again. But in a lot of ways, he either didn't care or he's got arrogant. And I think the experience of people in this case that they think they have is how we led to this mistakes. Mr. Phillips sitting right there where any of us could sit. He's like, I've got 35 years of experience. Don't question me, don't doubt me. Well, a lot of times success can be the greatest cause of failure. Because you've been successful in the past and you cut a corner, you leave a stone unturned. That's what happened. Now, Mr. Phillips also reacts to the attack, of course. And notice how everyone, the innocent people, the reliable people, the credible people, the non-law enforcement people, the video show the same thing. People reacting to the attack. So we just won't know what happened. That's another thing I like. Confirmation bias, availability bias. Basic psychological principles. Our mind puts things together. It's how we're adapted to behave with incomplete information and fills in the gaps. But how does it fill in the unknowns? Depends on what you're trying to confirm. We've all experienced this. You're expecting to see something, you're going to fill in the gaps consistent to that. And also availability bias in your experience. So there's been this experience of shootings in the neighborhood, conflicts in the neighborhood. Detective Thorpe arresting young people like Mr. Phillips who look like him and act like him, who are not innocent. And that's the availability that he has to rely on. And so I don't think we can know what really happened. It's not Mr. Phillips' fault. Now, it really could be that the shots came from somewhere else, from behind that tree, from the grassy hill that's not investigated, from the van, from inside the van, not leaving a casing, from a revolver, not leaving a casing. How did that never come up anywhere? That a revolver like the one Mr. Phillips had doesn't eject the casing. I mean, there's 3 shots. There's 5 or 6 shots in revolvers that never came up because of the confirmation bias availability bias. I'll even admit and confess that I fell victim to those biases as well. I looked at the evidence and I'm like, oh, this is not take guy. It was him. I gotta blame him. I read that, taught me a lesson, taught us why we have investigations. But it really could be that everyone's looking that direction because the assassins are not with 2 guns. Yeah, there's been things video recorded. Shots have come from that direction before in this history of conflict, where Mr. Phillips just happens to have to stay with his mom, or he doesn't even have a key. Stays nearby, and you gotta live somewhere, gotta be friends with someone. Could be a coincidence. There's so much violence. Could have been this little conflict, and then someone else trying to kill G, trying to kill Mr. Parks, trying to kill Mr. Phillips, trying to kill Miss Henderson, trying to kill anyone out there, trying to kill Mr. Arnold. We just don't know because we didn't look. And again, that's why the burden's on the state and the police. Mr. Phillips had no power over that. So what does he see when he gets out his phone to start recording that other people actually did? And we can presume he's been around people doing that. He's seen videos of people doing that. That might be a way to stop this from happening so that the real person can sit in there and be held accountable. It doesn't happen because you see how quickly everything unfolded. We talked about hearing shots, the trauma, the volume, the confusion, the chaos, the fear, how you have to get to a video. Some of you might have iPhones. You gotta unlock it if it's locked. Even if it's locked, you gotta press camera. You gotta press a very small part that I even sometimes had trouble you know, slide it, or it's not a photo, you gotta slide it to video, and you gotta hit record, and he wasn't able to do that. Just like the innocent people that tried something like that also weren't able to. And then you gotta wonder if there is people able to do that or have videos that they didn't provide, that they're scared about providing. Or that they're connected to this attack. We know there was an attack. And he reacts differently, what reason? Just like everyone else, he's pointing that way. He's pointing his phone in the direction that Mr. G, Mr. Parks are pointing their phone. They're justified. And as he's escaping that, he gets out his .45 revolver that doesn't need casing. That's a higher caliber. Where you see that big plume come out when he does shoot at his car. And you don't see those plumes with Mr. Parks' pistol. The gunshot residue guy who I found reliable and genuine. Not, you know, just promoting power of the system and persisting. He shared with us that, yeah, every gun's different. Higher the caliber, bigger the explosion. So what happens next? He escapes. They all run away. They believe they're attacked. They don't necessarily exactly know from where, or they believe from a certain way. And there's only one way in and one way out. I don't know why the state and some investigators keep going on, why do you run to the danger? Why go to the danger? First of all, they're assuming the danger was that house involved.
Mr. Menes, you need to speak up a little bit because I'm not asking you to face Ms. Rivers unless you want to stand way back there, but your voice goes low and it's hard for her. So you can either be at the podium or speak more loudly, which may mean you want to step back a bit from the jury. But she and I are both having trouble hearing you. More important that she hears you,
Of
but
course, Ron,
thank you.
sorry about that. And so they don't necessarily know where it's coming from, but regardless, the only way to get away in the car that Mr. Phillips came in is to run to the car. He runs straight to the car. And he's ahead of the other two. They're following him. So what conspiracy, what plan? And the state wants to, again, confirmation bias. It's prejudice against him, it's presumption against him. You're supposed to have the presumption for him. Why'd you drive him away? You guys are in a plan, you guys are in a conspiracy. If he did it, they would say, oh, you're such a criminal. You closed the door and drove off and let those two young boys stay there. Is that what they want him to do? And then again, in fear, he holds his revolver up. We see that. And then you see the way the plume comes out, the explosion, when he does shoot on the other side of his car. You don't see that anywhere else. There might be a little bit of it. I can't, you see the video, the judge is gonna let you take the videos back. There might be a little bit of discoloration on the dumpster at one point. So I don't know if Mr. Phillips accidentally went off while he's holding it up, or is that just something with the way the video is, the video that's choppy, that has importantly parts missing. Fact is, that's all after the death. And the one time that he intentionally shoots after the death and not into the house, and he's at the car while that van comes by that everybody either mistakenly or accurately believes is the attacker, but there's some attacker, and there's only one way out with the car. Mr. G and Mr. Parks, they shoot more, you see that. But they're still afraid, and I don't speak for them, but this is all after the death. They're not in trial for that. Some of the stuff after the death might fit the definition of aggravated assault or criminal damage to property, but it's after the death. The judge is gonna instruct you that it has to be an approximate cause of the death. That's logically impossible for anything after the death to be the cause of death, whether criminal or not. And importantly, it's the new video. This video that was never seen, that was shocking. To see that they made a decision in a murder case against two young boys, facing a murder charge. If it was shoplifting, it would still be just as bad. But then in a murder charge, where we're here, all the state to the burden of labeling him a murderer for the rest of his life, that they would just, a week and a
So
half ago-
please don't say anything that strays anywhere near what punishment might be. Not the role of the jury, certainly not your role as an advocate.
Right, Your Honor. They're seeking to give him a criminal record, but of the most serious possible charge that we have. And a week and a half ago, the video comes out. It shows all this reasonable doubt. it shows G missing in the part where he's shooting at the car, not at the car, but he's at the car shooting. Get to that later. And then Mr. Phillips does fire a shot. We see that beyond a reasonable doubt. We see that explosion out of the tip of his .45 revolver beyond a reasonable doubt. With his right hand, that's important. When you're looking at the evidence and deciding for yourselves, not taking my word for it, pay attention to the handedness. He shoots with his right hand. He's right-handed. He's running up in the air out of fear, holding it up to show that, hey, I got a gun, stop shooting at me. Again, after Mr. Arnold's shot, and that shot does not go into that address. He tells her I fired it up in the air. You can't tell from the video where it goes. You can only presume. You need to presume innocence for things that are unknown. And even then, a judge will instruct you on accident. Again, a large clue. Everyone presumes a connection to this conflict. That's how it happens. And their logic is so flawed. They say, oh, it must be this house or it must be that house. So if it's not that house, then it's this house. That's not right. Could have been A, B, C, D, E, or F. They didn't even look. Again, presumption against Mr. Parks doesn't meet the state's burden. And then they pull Mr. Phillips in as a supposed party to this case against Mr. Parks that they can't even prove removed to burden on. Didn't even try. So they stop the investigation. They don't explore alternatives. They don't investigate the entire scene. They ignore all these direct eyewitness accounts from innocent, genuine people. And then they lead and lean on unreliable forensics. We saw that, and I'll get to that. And later, this was the final thing we heard about, that Mr. Phillips had a court-appointed lawyer. And again, reasonable doubt, doubts for which a reason can be given. This lawyer who failed him, who failed his duty, his oath, who's a disgrace to everything that I and my colleagues do and that I care about, that I'm proud of doing, especially for Mr. Phillips. I'm sure that me saying this will get back to him. I'm sure he has the skills to actually listen to his clients and advocate for innocent people. And we forgive him because the state couldn't meet their burden here. So what he did didn't have an impact on Mr. Phillips when you apply the rules to the evidence. But I hope that when he hears about us bringing this out into the light, that next time somebody tells him what happened, he doesn't just tell him it was goofy, he doesn't tell him a lie, and he doesn't tell him that the only way to get out of this is if you lie. There's nothing wrong with someone wanting to get out of it when they're innocent. You won't listen to him. That's what happened. So the theory never gets off the ground. I was gonna make an analogy like the gas station stuff that, oh, this is a plane. Okay, you know, someone on the jury shared that they're pursuing her pilot's license. If it was her first trip and someone said, you know, there's this chance that the plane won't land safely, you wouldn't get on it. None of us would. The standard we're dealing with is the highest possible standard in our legal system because of what we're deciding. Beyond reasonable doubt needs to be how you have to feel, I hope, when you're dealing with someone packing your parachute or landing your plane. You have to believe them beyond a reasonable doubt that it's gonna land, that the parachute's gonna open. You double check and triple check, you have training. Then, they introduce this photo from the phone, more persistence, they persist, they won't drop it no matter how much comes out. There's nowhere in any witness report or statement that casts any doubt on that being Mr. Phillips' phone. Anywhere. And now, when the case is in pieces on the floor at the very end, they want to cast doubt on what the defense is saying, shift the burden, create doubt in their own investigation for one of the parts that is clear cut in the report by Detective Thorpe. Then they bring in this. A young boy in America being dumb on social media, like a lot of his friends do, like a lot of people do, like a lot of the entertainers do. And when you step back and think about it, this case has really got me thinking too, that how much of our entertainment is violence. Music, movies, almost every show and movie deals with some kind of either violence or sexuality or combination of the two. And now this means they've met their burden because of this. And then their theory is it's like a snake eating its own tail. So, okay, it's not his phone because of this other stuff that's in there. But that phone has this picture in it. So it is his phone, and now we see he's violent, but also from the same phone. It's not, just doesn't make sense. State's right about that, at least. None of this makes sense because their theory is not true. And then it's even uncontested that these are blocks, but they're 9mm. So what does that add to make a big deal out of it being a Glock when it's a 9mm and it's all .40 caliber found at the scene? Not relevant. Now, this court is gonna talk to you about reasonable doubt, and the state is gonna try to twist it up and persist again. You're gonna say, oh, well, it's not beyond all doubt. It's not to a mathematical certainty. But yeah, unreasonable doubts are not what we're dealing with here, like the universe. How big is it? Where did we come from? How old is it? Okay, yeah, that would be an unreasonable doubt to say that you don't know if we're even in reality or if it's a simulation or anything like that, or they're having a delusion or they're dreaming. That's an unreasonable doubt. And of course, they don't have to meet their burden to a mathematical certainty. We're not in a mathematical process. Mathematical certainty is for math. A little bit, I'll just list these are instructions. The other attorneys covered it well. Justification, mere presence, mere association, accident, circumstantial evidence, proximate cause, transferred intent, which is only if the act you do that was done is intentionally unlawful. So you can't transfer someone's lawful intent and make it unlawful. Party to a crime, but there has to be some kind of assistance, help, advice, encouragement. Even if Mr. Parks is not innocent, what was the help? What was the advice? What was the encouragement? Yeah, it doesn't make sense because their theory is not true. Conspiracy, you have to agree to not be innocent together. We don't have evidence of that. So these are the important ones. Won't read them off to you because the judge is going to give you the instructions. Mere presence, can't add that to your non-innocence, just being present. Mere association, being associated with people who are not innocent. That doesn't count. What are the core values? That the state has the burden. What is your duty? To hold them to that burden. How does the state meet their burden? I'm sure in other cases they have, of course, but in this case, they haven't even come close. They need to use evidence to overcome a presumption of innocence beyond a reasonable doubt. So what's evidence? Physical evidence related to the essential elements of the allegation. Even the content of Mr. Phillips' character doesn't matter here. What he did after doesn't matter. What's in his phone doesn't matter. It's the physical evidence to the essential elements only. What else? Witness testimony related to the essential elements only, not rumors, not connecting the dots with these presumptions. So what is an evidence? Rumors, presumptions based on a hunch, a bias, character traits, or any criticism of his decision-making that's not related to the essential elements. So above all else, we presume that he's innocent. It's for these exact scenarios. It's the most important rule. It's why we don't have to be looking over our backs all the time. We can be law-abiding citizens. We don't have to worry that we're going to be accused of something we didn't do and get labeled as that no matter what. And yes, some people who should be held accountable aren't because of this rule, but the rule ensures that no one who is not accountable will be held accountable. So those times where a not innocent person is still out there because of the process of the rules, that's not a bug of the system, it's a feature of the system. And so think about what presuming innocence really means. Anything you don't know, anything you wish you could ask him or ask someone or see, you don't know, you decide the unknown in favor of innocence. What's a reasonable doubt? A doubt for which a reason can be given. Of course, nothing's beyond all doubt. A doubt for which a reason can be given. There's a lot of that in this case. Talk about mathematical certainty. The judge will read you what reasonable doubt is, and you'll see for yourselves what I'm talking about. Wavering, unsettled, unsatisfied, so even when your mind wavers, that's reasonable doubt. And you decide for yourselves, but I contend that once your mind's wavered and you have to talk about something or convince yourself of something, that was a reasonable doubt, and it doesn't just go away. Okay, if your mind wavers, that's a reasonable doubt, and you must acquit it. The judge will read you that. Again, it goes even further than the verdict. The only way you can say he's not innocent under these rules is if the evidence excludes all reasonable theories of innocence. So they have to prove their theory and then exclude reasonable theories of innocence. Here, it's not a theory, it's beyond reasonable, and it's the truth. Grave suspicion, just having a grave suspicion is not enough. They try to do that on him. There has to be criminal intent. The judge will tell you that you're bound by these instructions, even if you don't agree with them. So, get to the video, you can watch it yourself. He's right there, standing with his phone. Even Mr. Thorpe, Detective Thorpe, admitted that he can't tell if he's holding a phone. Which means he could be holding a phone, which means under the presumption of innocence, we presume he's holding a phone. He's unreasonable fear of attack, just like the other witnesses told us. He's not the only one holding up a phone, and he's got his right arm down, holding his gun in his waistband, while he's holding up the phone trying to record. And then this is a video where we see him with his actual gun. No firearms expert to say what kind of gun that is. There's no burden on him to hire someone like that. The state needed to do that, and then they would have let this go. But that's what it looks like with a gun in his hand. And yeah, he shoots intentionally. And you see that video up around here. Mr. G is right there, he takes his arm kind of out, and then you jump immediately to, they're already in the car, and it's a two-door car. So you have to put the seat down, get in, wait, all that time is missing. And all in this area, G is shooting, it's not on video, which is weird. Then the van goes by this way, and you don't see if any shots are coming from the inside of the van, or if it was a revolver or not, if that's what happened. And then you see him shoot, he shoots with his right hand. And then he escapes after Mr. Arnold stops looking. I'm gonna go through the witnesses very briefly. You have your own notes, you have your recollection. Split them up into 3 categories: police, forensic, and citizens. This is who was available. You remember? And I have a list here. I'm gonna go through them. Here's who's not available, who I can't go through. Not Mr. Phillips' fault. Mr. G, you don't even hear testimony of anyone looking for him. What is that? What is this? This is not how we do things. This is not how we put charges on. And it's not like it's a mystery. We had testimony that people know his grandmother and where she lives. Sam, Blakeney. Who knows who else who might be scared to come forward or connected? All these other investigators, the attorney. Then we have the forensics. Hovind and Henninger, they're doing actual science. And then Mr. Francis doing this government police science I'll get into a little bit. So now what I want you to do and think for yourselves is compare Mr. Jarvis to the actual science. That's why I was asking those questions that way. I'm sure they were confused. So is there any physics, chemistry, computers involved? Like he said, there could have been. Was his work checked on by anyone else who's reliable? Is the methodology developed by a neutral source? It's not even something at universities or anywhere neutral. It's fully created by the government and the police who then try to use it. It's like a circular system. Oh, we're checking our own paper. And even if the methodology is reliable, were those continuously updated, or are you doing what you're confident in for 45 years ago? Again, success leading to failure. Awareness of national and industry standards, and accreditation or certification, even if you don't think you need it. Dr. Henninger laughed at me and didn't know why I was asking that. He's done 10,000 autopsies. I said, well, you couldn't give yourself accreditation. even though he did 10,000 autopsies, and he laughed, and he said, "Oh, yeah, of course not." And they might say they're an expert, they might have whatever expertise they have, but the decision is yours. Judge McWordy will tell you that testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. So what do we know about his supposed cartridge comparison? We had a lot of testimony that the scene was not secured against contamination for quite a long time. And he's not accredited, never been accredited, not familiar with the standard, using old methods, no computer or technology involved, not an actual science, there's no sophisticated instruments or certainty. It's this older gentleman who I think will be fun to hang out with or babysit my son or talk about stuff, of course, but not for this. Making a visual comparison that's subjective. Involves human interpretation, and anytime there's human interpretation, there's a possibility for error. And we didn't know anything to prevent that, no oversight. It's not reviewed by any peers or university, and he can't give us an error rate. And even if he could, even if it said 97%, would you get on that plane? Would you use that parachute if you were told there's a 3% chance it's not gonna work? No, it's not good enough for something like this. My manufacturer, we got into that already. 3 groups, 16, 12, and 3. And even if we take what he says that's true, it doesn't get the state to their burden against Mr. Phillips. These are all the cases. You all ask really good questions, kind of made me feel like there was questions I didn't answer. I like that. So you look at this picture yourselves and think about the doubt that it creates with those groups. Again, real science. This is what we can know beyond reasonable doubt. That Mr. Arnold would look dead moments after he was shot. That there's a good chance the death was nearly instantaneous or appeared like that under our regular definition. Under Mr. Phillips's regular definition. And the wound was from the left side of the neck, and we don't know, and no one else knows, the position of Mr. Arnold at the exact time he was shot. The real science talks about the plume, talks about how different guns would look, and depends on each gun. That's why Mr. Parks and Mr. Phillips's guns look different, because they are different. Different ammunition. Now I group the police next. This is what I think the evidence showed are reliable, truthful police. The dispatcher talked about innocent people not wanting to tell their names, having evidence they don't come forward with out of fear. Officer Carter, he's not necessarily serving the system in the same way as Detective Thorpe. He admitted about what happened when we arrived on the scene. 10 people, firefighters, police, for at least 7 minutes, walking all over everything. These pictures are not taken even close to the time of the shooting. Casey is getting driven over. And Investigator T, he seemed sincere and genuine. He collected some video. He also didn't collect a lot of video he could have with warrants from Ring all over that neighborhood, no matter how afraid the innocent residents were. And again, it's not Mr. Phillips' fault that he lives in an area where people are afraid to do that. There's other areas where if something like this happens, there'd be 50 911 calls and everyone lines up at the police station to give over their video. But he doesn't live in an area like that. And Investigator T just did what he was told. He's not an investigator like that. He's an investigator that is given a task by someone like Detective Thorpe and is qualified, and I think he was honest about that. The photographers were honest. Officer Carter wasn't fully honest when I challenged him about something and the doubt started to creep in. Talking about his made-up rule, again, the persistence, his made-up rule that, oh, I can't take pictures until a medical examiner shows up. And then the good-hearted, genuine crime scene photographer tells us, I never heard of something like that. That doesn't make sense. And they talk about being at the direction of others. They talk about the importance of painstakingly documenting everything. That wasn't done. Now, what do we know beyond reasonable doubt about Detective Thorpe? That he's an unreliable, known liar. He lied right to our face, right in front of us. He tried to fix his answers to some of my questions by using the video that came out a week and a half ago. That right there means you must have quit Mr. Phillips on that. There's no burden on him, the video actually proves that he's innocent. He sat here not knowing what we had heard from Ms. Stallworth and lied right to everyone's face, under oath, so help him God. A part is missing near the car, that adds value. What else could be missing? Well, talk amongst yourselves. So ask yourself, does he serve and protect, or does he persist and preserve? Looks like he'll do anything to preserve his investigation. I think Judge McWordy made a wise comment at the outset of this. He said, pay attention to how the witnesses act differently depending on which side is asking the questions. So piece that together. I can't believe he even said this, that we just gotta take his word for it right after he answered my questions about why reports are important. That is not how it works. We do hold people accountable. The state does meet its burden sometimes, but not like this, not like this. Go to his interview, supposed interview with Mr. Parks. Of course, Mr. Parks acts a bit young and dumb at the beginning, that he's scared the way the rest of the innocent people in the case are scared. And Thorpe already has his mind made up. It's not an interview, it's an interrogation. He's got his mind made up. He's using a tactic that doesn't make sense for the scenario. Imagine a different scenario where someone is afraid of their abuser or their trafficker. You use a more delicate way to get them to open up. Didn't do that. He just screamed. He hates being challenged. Mr. Parks is making intelligent, good challenges. He said, what do you think, I just started shooting out of nowhere? What are you saying, that there weren't 3 shots? And Mr. Thorpe even admits, yeah. Well, I'm not saying that, but I don't have video proof of it. Again, shifting the burden makes no sense. So you're gonna put charges on people just because you don't have proof that they didn't do it? That's not how it works. It's not how the judge is gonna tell you how it works. And you see how he hates being challenged. You saw what he did even with me. He said to Mr. Parks, oh, can't GED your way out of a PhD situation. And he comes in here when the tables are turned, when I'm the one doing the interview, and he tries to PD his way out of a JD situation. He tries to get up and intimidate me, square up to me. We saw that, that was, do with that what you will. He's probably used to that because the system always protects him, which is terrifying. That this system protects Mr. Phillips. And he says the whole case right in this one sentence. It could be a phone in Mr. Phillips' hand. Yes. Done. I cannot possibly say they met their burden. But then he turns around and says he can for sure tell that Mr. G's gun was jamming because he wants to put evidence from the scene on Mr. Phillips. Even though we saw the video ourselves, and you can't tell that. Now I go to who I believe are the actual most reliable, neutral, credible witnesses. Okay, Miss Harris and Miss Hammond maybe had something to do with it, maybe didn't. You can wash gunshot residue off your hands. We don't have all the video. There seems to be stuff missing from G, so how do we know there's not more missing from somewhere else? Ms. Stallworth, who gets us this exonerating new video for us about a week and a half ago. Now, I don't want to speculate or presume like Detective Thorpe, but I kind of wonder what someone like him would have done if he saw that video just on his own and knew we were coming to trial in a week and a half, and that it exonerated Mr. Phillips. Miss Dixon, she heard the attack, just like multiple other people. And then the state goes in and says, oh, but she's not credible because she's related to Mr. Parks. Okay, so you're just flat out not to be believed at all because you're related to someone when you are a direct eyewitness to their innocence. She seemed credible to me, at least a reasonable doubt that she was credible. Now we get to another citizen, I think the most important one, Miss Snow, who we call Snow. She doesn't get every little detail right, but she is reliable and credible for the big facts, the things that would stick in your mind. Not where exactly anyone was at any time in the driveway, but that she sees how it has gone up while Mr. Arnold was shot. And when she was asked an open-ended, neutral question with time to think about it by the state, she was asked, when did you first see Mr. Phillips with a gun? And she said, down the street. She's the only one, when Mr. Rowe asked her a leading question that was compounded with his client that she did see shoot, just needed a quick yes or no answer. He goes, oh, so that was when Will and Hot Shot met, right? She says, right. But she's thinking about Hot. And that's why I was like, well, that can't be right. Let me get up and ask her. And I said, ask her again, open-ended, slowly, neutrally, directly. When did you say you first saw him with a gun? Earlier, before that leading question? She said down the street, and she was right there. Now, I don't want to speak too much for Mr. Parks, but my client's being charged as a party to him. Ms. Snell testified that she thought Mr. Parks was the intended target. We don't have any reason to think that's not reasonable for her to think that. She's innocent. She wasn't involved in this, and she thinks Mr. Parks was the intended target. And we're supposed to think it's unreasonable for Mr. Phillips and Mr. Parks to think they're the intended target, wherever it's coming from. And again, of course, there's race in the case. Sometimes people say, oh, playing the race card to try to get us not to talk about it. But then look, there's even deeper issues. Power again. With Thorpe and now the race is switched, but the dynamic's still the same. Who has the power? Who doesn't have the power? Who do we believe? Who do we not believe? Who controls things and who doesn't? And again, I just have to say that if anyone else was killed, there might be more investigation. And if someone was killed in another area, there also might be more investigation. But out of that power and persistence and presumption, the state just has to come in here and ask you to get justice from Mr. Arnold when their own actors who were responsible for it didn't care about getting justice for him. Can't fit a square peg in a round hole. You can say what you want, you can look at the video, you can try to trick people into saying stuff, but we have citizens who witness the thing in a video. Mr. Parks gets good points. And any conspiracy theory that the police make up just doesn't make sense. I still don't get it. I still don't get what they're thinking when they wrote these warrants. Like Mr. Parks says, you thought that at that house that's so far away because there's been a conflict between these two addresses that I just got out my gun and started shooting in the middle of all my own family. And when they have the chance to investigate the truth, it falls on dead ears. I talked about this already. I don't have video proof. All of a sudden, he's saying things that don't show up in his report to try to fit this square peg in a round hole. Oh, I thought I was bringing up some good points. That's for you to decide. He said, oh, that camera was down, not in your report. That's not the only thing. You can check your memory and your notes. All of a sudden, when something made the burden unmet, or when there was some reasonable doubt, all of a sudden, something that's not in the report gets put on the record by him, who lied to our face about the video and relying on it, when we were told moments earlier, a day earlier, that was not gotten until a week and a half ago, and his conclusions that he says he makes with the video were made years ago. Now, I don't think I need to belabor this point too much. We all saw it for ourselves, didn't have any questions about it. There's also the citizens of Miss Gates and Mr. Phillips. Miss Gates is Mr. Phillips' mother. A lot of institutions have failed Mr. Phillips. And at the end of the day, the only ones that he ended up not failing him are motherhood and jury duty. She steps up when the system failed her son. She finds out what the court-appointed attorney that none of them chose was doing. She found out how things were going. But the only available advocate for a vulnerable person, that's the person you're supposed to rely on. They're not listening to you, telling you you're goofy, telling you to lie. So this is just one long sentence. I do want to read it to the record. I don't expect you to remember it. But these are things I want you to look out. A doubt for which innocent reasons can be given. That's what, think about the instruction on reasonable doubt, and then think about this with everything we heard and didn't hear. Mr. Phillips has a reason to be there. He has a reason to be in fear for his life. He has a reason to have a guess about where the deadly attack was coming from. He has a reason to try and record on his phone with his left hand while he's clutching the gun in his pants with his right hand. He has a reason to be unable to record, a reason to drop the phone, a reason to run, a reason to have a gun on him, a reason to get the gun out after Mr. Arnold dies. A reason to hold it up in the air with his left hand, a reason to escape, a reason explaining why no shell casings are left behind, a reason to shoot in the air when he's behind the Mustang, a reason to drive away, a reason to let Mr. G and Mr. Parks ride along, reasons to keep things to himself, reasons to explain the contents of the phone that he used in the driveway to try and record, and many innocent reasons to lie at the prior hearing before I was his advocate. Before I listened to him and didn't call him goofy. And pretty much did not turn out to be goofy once things came out of trial. That's why we have trials. That's why we have jurors to hold the state to its burden, to hold the state accountable. And again, do not take my word for it. I just, I'm his advocate. I'm biased, of course. I'm gonna come up with all the reasonable doubt I could think of. I'm gonna seek out doubt, and the judge is gonna tell you not to be with the fact. These are not things I came up with. Do not listen to me. Do not take my word for it. Like Bill says, look at the evidence yourself, apply the rules to the evidence. State did get this one part right. Doesn't make sense. Yeah, because what they failed to prove wouldn't make sense. It couldn't make sense. The theory doesn't make sense because their theory is wrong. It hasn't met the burden. The burden of proof beyond reasonable doubt. I wish I was taller to make a better example. We have suspicion, probable cause, preponderance of the evidence, beyond a reasonable doubt. There's no higher standard to get over the presumption of innocence. So like we said, we saw power, we saw presumptions, we saw persistence in favor of those presumptions and in service of that power. But now there's a different kind of service. There's going to be 3 other P's. Of course, your duty is always serious, but when you represent an innocent person, it's especially tough. There's an especially heavy weight on your shoulders, but now I take that weight. I feel good.
Excuse me one second.
Hold on 1 second. Do you have water you good? All right.
So now we're gonna take
No,
those 3 P's.
we're not. I'll let you know when we're ready.
Sorry.
The 4th P is patience.
Yes, sir.
Okay?
Yeah.
Now the P of proceed.
Proceed. Thank you. I apologize for my lack of patience, and now we proceed. What we proceed with, that I'm proud to tell you all, is to vote however you want, to participate. Because the only reason Mr. Phillips can even trust you all to do this is because jurors in the past have held the state to its burden. And a few principled people following the rules do have the power to change things. It's the only thing that ever has. So we need people participating. We've seen in history how quickly something can go away when people don't participate. Promises. Mr. Phillips has promised certain civil rights that were all promised that don't come, you can't earn them like an accreditation, you can't lose them. They're in you because you're a human. So whatever you believe in, however you think we got here, that's where those things come from. And we don't always fulfill that, but I just know we'll fulfill it here. We'll participate, we'll fulfill the promise and what's promised to him and all of us on paper. These rules, these civil rights, through a process. And I've been glad to go through the process with you. A case like this has made my life worth living. I hope that you guys share in some of what happened here and some of what your duty entails. And again, vote how you see the evidence according to the law, not what anyone else tells you. Thank you.
Thank you, Mr. Monetis. You take your presentation down, Mr. Greiner. or Ms. Porter, part 2 of the state's presentation.
Make no mistake, these two are predators. They're not prey. Don't let their look, don't let their appearance, their age fool you. They aren't predators. They're not goofy. They're predators. This is what it's about. It's about guns, glorification of guns. My colleague says, well, it's society's fault. Well, it's not. Society didn't pull the trigger 31 times. Here's Phillips still with 2 guns. That is what it's all about. Just so we're clear, these are the different players that have been identified in this case. We've got G on the left, it's been testified about. Hot Parks, who's Kerry Henderson's son. We've got this person in the middle that no one seems to know who that is, just walks the neighborhood. And we've got DeMario Phillips that goes by Whoa. So walking through the video, here we go. We see Phillips, we see Parks, and we see this person named G walk past Sam. Sam is clearly on alert. This person who walks through the neighborhood is now on the right, and we see Woe walking past there to the left. Now we see the girl. She's going to come get in the car with Sam. And they leave. Sam was right. He was right. He saw trouble. He recognized trouble. And he left. Sam was right. He got out of there. He knew what he saw. He saw trouble. He saw Phillips clutching. He knew that there was a problem. Now, just for time reference, we're just going to stick with this video perspective. This is after the murder and after the run around the building and after the Mustang is screeched away. This is Kerry Henderson's car leaving at 6:31. So just to go back, here's where Sam and his girl are leaving in 1827, 54, just before 1828. That would be 6:28 in the evening. Now they're gone, 20 seconds later, and a lot happens in the next couple of minutes. Here's Kerry Henderson's car leaving at 6:31:33. And here's the sister, Parks' sister, who testified, leaving at 18:31:40. So a lot has happened in the intervening couple of minutes. So let's look at this perspective here. This is State's Exhibit 17. We still see Sam's car down to the left, and we see the group of people. They've already walked down to Kerry Henderson's house. And here we see our neighborhood walker walking back up the street. If you recall in seeing the video, he walked down there with the group, and there was some intermingling before the neighborhood walker comes back up. What happens next? When he gets up here, look, he turns around. Sam's already in his car. Sam's about to leave. But what's the neighborhood walker looking at? He's not looking at Sam. He's looking back this way. Because you see, there's been some kind of conversation down there. We'll never know what it was. We got a hint from what Miss Neal testified, but there's something that has happened down there. There's something that is occurring among the adults. And that's the only reason why our neighborhood walker would come back up here and turn around and start walking backwards, facing all of this, because he is anticipating something to happen. And it does. It does happen. He heard something that told him another piece. And so we talk about circumstantial evidence. We've got Sam, who's there. He sees these two plus their friend walk past. He knows that there's something up. He says, girl, let's go. And they left. Seconds later, here's our neighborhood walker. He comes up and he turns around. He's watching. He's not looking at Sam. No, he's watching way out here to see what's going to happen next. Sam leaves. See? He's not looking at Sam. He's looking out the rest of the neighborhood. He's looking back so he can see what occurs. Sam leaves and we see Carrie Henderson standing out here in the street. And you see where this side street comes in. That'll give you a good reference point, a reference where she's standing. See, she had to come out that far in order to even get a hope of getting a picture up at the front of the neighborhood. That's because, as you heard the testimony and their photos entered, when you're standing there, and these people are standing here right here at the edge of the driveway, you can't see the front of the neighborhood. We'll look at a picture in a minute. So after she takes her picture, she joins the group. The judge is going to give you equipment to watch these videos. You can spend hours watching these videos. Let me just point out what you're looking at. This is Tobias Arnold before he died. And Miss Neal, the Caucasian lady, kind of on the other side right there. This is Phillips, the defendant over there. This is Parks, the defendant over here. This is Carrie Henderson in the red. And this is G. So Phillips was not inside. Parks was not inside. What happens next? Tobias is down. He's down. He's been shot already. He's down. Who's got guns? Phillips and Parks. They both have guns. Here's Carrie. She's headed in. It's not a phone. That's a gun. Look at this. He's moved out a little bit. This is a gun. He's moved out with his gun. Phillips has moved out with his gun. Parks has moved out with his gun. Parties to a crime. They are right now committing the conspiracy. We're going to shoot up the house. See, when Sam's out there, this is how chicken these are. These people are. When Sam's out there, they're not going to shoot then, because Sam would shoot back. No, they're going to wait until Sam drives away, and then they're going to light up that house. It's exactly what happened here. When Sam left, Carrie came back and said something. We'll never know what it was, but she said something. They decided what they were going to do. That's your conspiracy. And you know it by what they did. They lit up a house. They lit up a neighborhood. They lit that house up with 9 people in it, 6 kids. They hit the neighbor, 2, that house. 3 rounds, and they hit the other house on the corner with another round. This could have been the kind of story that you read about in the news, which makes national headlines. Now they run away. Parks has a gun. Phillips has his gun out. and here's G. There's Parks's gun on the left. It's very clear. There's no question he's holding a gun. He was just firing it over here at the edge of the driveway. Here's Phillips with his gun. G is struggling with his gun. His gun, he probably jammed it like Detective Phillips said. If you recall the evidence, there was one unspent round out there in the driveway. My colleague is unsure about his own exhibit. I'm going to explain it to you. Mr. Jarvis put these casings in this bullet holder in order. So number one, evidence marker number one was the body, right? And then he just starts filling these casings in. You're going to see number 6 is a live round. The 610, that's the live round. That's the live round that's out here. It was deposited and it was found in collector's evidence piece number 6. There's no mystery. You see, G is the one who didn't have his gun out early on down here. G's, he's struggling with his gun over there. He ejects around and jams or something, who knows. But you see, G is the one who's not shooting so much. These two are the ones who lit it up. And you heard what Mr. Jarvis said. One gun shot 3 rounds. One gun shot 12 rounds. One gun shot 16 rounds. These two have the guns that shot 12 and 16 rounds. Let's keep looking. After the boys run away, what does Carrie Henderson do? She walks back out into the street. Her own actions tell you that there's no one else out there shooting. No one is going to walk right back out into the firing line if there's someone else shooting. Her own actions indicate that. Their actions indicate that. Like we were talking about yesterday, no one's going to run right up toward some attacker. It does not make sense. Sister is not going to get in her car and go drive in the direction looking for the attacker. That was crazy. Parks' sister was recruited to do the dirty work that Carrie Henderson could not do. You all heard so many things about how unreliable Carrie Henderson was. The defense team knew that they could not call her as a witness, so they sent the daughter in here, and she came in and parroted what Carrie would have said. This whole crazy story about there being another person out there shooting. Carrie Henderson's own words and her own actions belie that. She's not going to walk out the street if somebody's shooting down there in that direction. And guess what else? Look at all these cars down here. Remember, the damage to this car came from the other side because that's where the bullet was coming from. Look at all these cars down here. That car, that car, that car, that car, this side of Granddad's car, these houses, garage doors, this box, all of that. You shoot in that direction, you're going to hit something. And this place was crawling with officers. They're going to find it. It's crazy for them to suggest that the police need to go out and start taking pictures of empty grass. What, you didn't think they took enough pictures? They took a lot of pictures. They took a lot of pictures, but they're taking pictures of evidence. What's going to advance the case? Not a bunch of nonsense. I've just cleared this, okay? If somebody's shooting at these guys, there's going to be something else hit. There was no other shooter out there. It was Phillips, Parks, and their friend. Those were the only 3 shooters out there. That's why the ballistics evidence shows 3 guns only. G shot 3 times, one of them shot 12, one of them shot 16. Okay. Judge, is there a way that we can move this time to the top?
I'm not sure I don't know what's on the screen. And there's something that says 182905, but that looks like that's embedded on the video. I can't see the screen you're talking about. I'm sorry. It's not on the screen. I'm looking at the same thing I just don't have that there. I'm sorry.
All right. What we're looking at the top of this, you'll have the equipment back there to look at the video. This is exhibit 23. Okay. And this is the front door view from 4215. And show a little bit of it earlier in the evidence. So this is after the main, the shooting down at the other residence, 4226 has occurred. And Tobias Arnold is already down on the ground. And here these guys come up around 4215. This is critical to understand because, we can't read anybody's minds, but part of what you can consider is what somebody's actions are after the murder. How are they acting after the murder? If you had any question at all about what these guys were about, gee, is it malice or not? Are they acting with an abandoned and malignant heart? The answer is yes, because then they came up around and they shot up this house. They turned their backs toward, the direction of where they are now saying Sam was and this other attacker. And when they come around this corner, there are certain shots that we're going to look at. This is Parks right here, and Phillips is right here to the upper edge of it. I would encourage you to look because what you will see is in his hand is a handgun and it's not a revolver. What is in his hand is clearly a handgun with an extended magazine. There's a blow up of it. This is here's his hand, the handgun, and the extended magazine. It's just like this. Not saying that these are the guns, but you see how his hand does not cover the extended magazine down here? Why do you have an extended magazine? Because you have a lot of rounds that you want to load that gun with so that you can shoot a lot of rounds. That's why. It's an extended magazine. And you heard Phillips testify yesterday. He knows guns. He may know guns better than I know guns. He knows guns. He had an extended magazine in the gun, and here is the proof. And this is, you'll see it on State's Exhibit 23, that video where he is rounding the corner and he's got that gun in his hand. Not a revolver. He had a semi-automatic weapon with an extended magazine. So here's another image. Here's Parks. Here's Phillips. See, Phillips has his hand raised. He's not filming anything. He's got a gun. Another image, he's got a gun. Here's Parks holding his gun. Here's Parks holding his gun again. Now, someone may say, well, I don't know what this is. Is that a branch or a tree or something like that? That's why we have this little inset here. So you can see the background against the truck. You see the truck, the white truck over here in the inset, it's all white. There's a tree there, but you see it's because Parks has his arm up. It's in front of the truck here. That shows that this isn't some branch or something that just figment or just came up. That is his arm holding up. He's directly pointing up toward 4215. He's right there at the edge of the sidewalk, or the edge of the boundary. There's a close-up. Parks is holding his gun. He's pointing it directly at the house and shooting. And that's the truck back there that was used as a comparison. So here the two are rounding the corner, continuing to shoot. Look at this. Parks has his gun, arm still pointing up at the house as he's going by really closely. Phillips has his gun up. This is the extended mag. You see his arm is coming up straight, and that magazine is at an angle. This right here. This is an indication of the extended mag. I wish we had a Hollywood, quality, clear image of that. It'd be great, but it's not our fault. We take the evidence as we get it. A lot of cases without surveillance evidence. A lot of cases without video. In this particular case, we have the video. And it shows Parks and Phillips, both with guns, lighting up this house. You know that they're close because this is part of the house right here. That structure right there in the upper left-hand corner. Look at that. That's not a revolver. Phillips lied to you yesterday. He didn't shoot a revolver. He had a semi-automatic weapon with an extended magazine. That's what he had. And ironically, he said that that's what he had at his immunity hearing. Remember? Yesterday he said, I had a Taurus Judge, it's a revolver, it shoots a .45 caliber. But you recall when I asked him questions about his immunity hearing, no, he said at that time he had a Glock 40 caliber and he shot, I forget what it was, 10 rounds or something like that. Oh, but it was the lawyer that told him to do that. Well, would it make sense for a lawyer to risk his career in this case? Does that really make sense? Gun with an extended magazine. This is not a branch, something in the background, because we've got this offset over here showing what the background looks like. The only thing that's pointing up and obscuring the background is Phillips's hand and his gun. Here's the barrel and the extended magazine. I would encourage you to look at the video yourself. It's jumpy, not the state's fault. Do the best we can, but there's your close-up. Extended magazine, just like the one that he's holding above his hands. G did have a gun. G did shoot, but he had his gun out very little. He's got a gun there in his hand. You can see it. He's not one circling the building, shooting, doing all the other stuff. You don't see him down the other driveway shooting. You see these two, Mr. 12 and 16 rounds. G's the one who shot 3. See there, G's run. He continues running. He's actually tucked his gun away at that point. Here's our white minivan, unrelated to the case. And here's the Mustang leaving. Compare the times. White minivan leaving, this is a 23, 18:29, 23. Mustang leaving 33 seconds later. Remember when Fats went walking away, went walking up toward the front, he was on the phone or something, I think you heard testimony. There he goes walking up to the front of the neighborhood. You see at the time, 18:33:14, and the first officer is arriving at 18:35:40. So, pretty tight time frame. A lot happened in those minutes. Thank goodness we got video, which tells the truth. The video isn't lying. It's not perfect, but it's not lying. Different angle. Sam's car leaving. Would it make sense for Sam to get his girlfriend in the passenger seat and then turn up there and get out and start shooting? No. No, it wouldn't. Sam had nothing to do with this case. Except if anything, just prevented him from shooting for a few minutes. Till he left. Kid's playing basketball, and then now he's running. He's running because he's hearing gunshots down at the other house. You notice the time, it's like 1:18 into this clip. We'll have this video back there with you. Kid's running, these neighbors are starting to react. The gunshots they hear way down there. And here come the defendants rounding the corner. Parks and Phillips. Phillips is in the white pants, Parks is in the dark pants. There they go. Phillips got his arm up because he's shooting. You saw it from the other angle, and here's a different angle. Parks here, the red, he's got his arm up. Look at that. Is there any question that Parks is now shooting at the house, which is right there? And Phillips is shooting at the house too. You can't really see it, but you can see how his left shoulder is a little bit inclined. If you look across his top of his shoulders, everything's kind of inclined. That suggests he's got his arm raised. It's a little bit obscure because of the background. Here's a little bit better picture of it. Parks clearly shooting. Phillips has his arm raised because he's shooting too. A little bit better picture. See, here's Phillips' arm extending up here in some manner. And I have to say that the whole idea that you can't see the muzzle blast, so they're not shooting. Is that basically what my colleague? You saw the casings. They're all around up there. Casings everywhere in that area. And is there a suggestion that there was not actual shooting, actual muzzle blast? That the only time that Phillips was shooting was near the car, because that's the only time you see a muzzle blast. You don't see any muzzle blast out of Parks right here, out of his gun. You know he's shooting. You saw all the shell casings up there. No question at all, he's shooting. And again, yes, the deceased is already on the ground, but it doesn't matter because this is one long continuation of that. And if you have a question about malice, here's your proof. What are these guys about? An abandoned and malignant heart. They have literally abandoned the next door neighbor. He's related to the guy, Phillips. They have abandoned him and left him there to bleed. And his girlfriend too. Predators. Don't let their appearance fool you. They're predators. Predators. An abandoned and malignant heart. Look at this picture. Parks is he's in the air, he's airborne. You'll see it. You look at that video again, he's having fun. This is fun. Doesn't require an intention to kill. I want to kill somebody. What it requires is that abandoned and malignant heart. Don't care and you're doing something wrong. That's an abandoned and malignant heart. You kill somebody, that's malice murder. Look at it. Fun. And here's Phillips over here. Got his arm raised still. He's shooting. He's not shooting in the air. His arm is angled toward the house. Look at that. That's his arm. I've got this time circled down here at 1:37. You see, Parks, he's kind of put his guns down. Here's Phillips with his gun still in the air. If you're not sure whether this is his arm silhouetted against that white car, here's a close-up. But here is a comparison of the white car without Phillips walking or running past it, and the white car with Phillips running past it. And you can clearly see that his arm is, it's silhouetted, or it's in front of the white car. And there's that gun again, with the extended magazine, not a revolver, semi-automatic with an extended magazine. And it's gonna eject cartridges all in this area. And so if you're wondering who put all the cartridges up there in that part, it's Phillips. He's the one. Parks has kind of put his gun away. There's Phillips again shooting. Look at this. Here he is kind of alongside the car, maybe close to that side view mirror, maybe not quite close to that side view mirror. Got his arm up in the air. Here we go. Now he's down near the rear wheel. Look at that. Look at that gun. Look at his arm, the gun, and the extended magazine again, extending down. He's shooting that big old gun with the extended magazine. He's the one that put all those cartridges up there in that area, number 28, 27, 26, 25, all those cartridges there around the red Mustang. If you're wondering who put those, very likely Mr. Phillips, because he's the one still shooting over there. It's not a single revolver shot to scare, no, in the air, just want to shoot a revolver. Well, he may have wanted to shoot a revolver one time, but he also shot all those other times out there with and deposited those shell casings on the ground. Here comes G. G's done some shooting too. But he did 3 shots. The evidence indicates. So now they're getting in their car, that red Mustang. And this is when Phillips gets right back out of the car. See, he sits in the car, and then he gets back out of the car. Here he is shooting, and here's his arm. And you see, this is, again, silhouette. This inset shows the car with nobody in front of it. The video shows Phillips standing out of the car and pointing his gun and the plume of muzzle blast, as you can see. It's really more of an angle than anything that's going to show you the muzzle blast. But if you're wondering what these guys are about, it's shooting at the house. It started down there in their own driveway, and it continued up and around this house. It is absolutely shameful and horrible. And here goes the white van. At 1:47, see, I've got the time circled down here, 1:47. The white van that had nothing to do with this case. And then here they come. Remember the other time was 1:47? And here they come, 12 seconds later, they're leaving. If that white van had anything to do with this case, they could have pulled down and lit up the Mustang when they were in it or something like that. Who knows? That's something that they have come up with here in the courtroom. That's not real life. That's not what happened. That is a fabrication. And I'm not pointing fingers at my colleagues. Understand this. The defense comes from these defendants. The evidence makes sense in this case. All these evidence markers down here near Mr. Arnold's death occurred down here, shooting this way. Sam had left. This house is, not that Sam was there as a guard, but as soon as Sam left, these guys knew that they weren't gonna get anybody shooting back at them. And that's just the plain truth. Nobody's gonna shoot back at them. That white car's gone. And so whatever conversation they had down there, these three guys felt safe in doing this. They felt safe in lighting up the neighborhood. They felt safe in running up the driveway, running up the road and lighting up 4215. They felt safe that there's nobody out here on County Line Road or somebody snooping around the building or whatever other theory they want to come up with, which by the way, it all was laid out by Carrie Henderson, the mom who left. She also left her neighbor laying out there bleeding and her other neighbor laying out there just trying to deal with poor Arnold who was bleeding to death. They left those people high and dry. And none of them would have taken these actions if there had actually been somebody out there shooting. And you heard Mr. Phillips up here yesterday say, well, I really assumed that the shots were coming from. That's crazy. When you all go back and you all decide what a reasonable person would do in this situation, just think, well, I assumed, and so I started lighting up the neighborhood. Is that what a reasonable person would do? Is that what a reasonable person would do? You all decide as a jury. Reason why they felt safe doing all this is because they had the guns, they had the power, and they lit up the place. Here is a perspective from testified about already. This is from the edge of the driveway at 4226. This is the driveway where Tobias Arnold died. You see it states Exhibit 117. You cannot see the front of the driveway or of County Line Road. You can't see the front entrance of this neighborhood. What you can see though is 4215. You can see 4217, which got hit, and also this one of these houses over here also got hit. But you know, these guys are not taking controlled shots. They're not responsible gun owners trying to defend themselves. It's ridiculous. They're predators. They're not prey. They're not goofy. Their bullet is just as deadly as the worst person you can think of. That's why the evidence shows the projectile is going this way. This car was hit from this direction. Granddad's car, who was parked on Oxford Court. 4217 was hit. 4215 was hit, but we also, you know, as they rounded the corner, they were pouring bullets in on this side too. And this structure over here, 322 was also hit. Bullets are going this way. None going this way. Respectfully, the defense here has been, hey, let's ask a bunch of questions and claim it's reasonable doubt. Well, guess what? These are the issues for you to decide. What's on the indictment? Not who the driver of the minivan was, or you know, what day of the week, or you know, just these things, other things that they want to bring up. What brand of, you know, none of that. The issues are here. The judge is going to tell you that you got to consider each of the counts and whether the state has proved each of the counts beyond a reasonable doubt. Think about what's occurred in the last few days. The defense started off blaming the residents of 4215 for their own attack. It's their fault. And then it switched to Sam. It's the guy out there with the gun. Sam's fault. And then it became the police, sloppy investigation. Place was crawling with police. They're looking for everything. They're talking to people who are uncooperative. And consider this. With these two running around, just shot up 31 rounds. Who's gonna want to raise their hand and walk forward? Officer, I saw something. No. Who's more likely to do that are the kind of people they're complaining about now who didn't come forward. And the sister and the mother and these people who are going to come in with these different stories, which turn out to be nonsense. The Atlanta police are no fools. They get out there, they listen to what people have to say, but they take it with a grain of salt. They're going to check it out. They're going to verify. They're going to look for evidence. They're going to look for video if there is any. A lot of cases don't have video. They're going to see what they can do. They detain Javante Harris. They check it out. No gunshot residue. None of it. These guys drove off. They got rid of their guns. They got rid of the car. They never came forward. Parks was in the cabinet hiding. Does that sound like self-defense? A reasonable person who acted in self-defense is going to stay on the scene, going to cooperate. Here's the gun I used. Here's where they were. They and their group all acted like they were guilty. Think of it like this. Shootings happen, the murder, these two run away, so did mama, so did sister. You know what? They were all acting guilty. That goes back to the fact that there was a discussion there. There was some talk. It didn't have to be long, didn't have to be elaborate. It could have just been kind of a, little talk or, whatever. Didn't have to take long, but there was some communication, it seems. We'll never know, and it doesn't really matter in this case, because these two acted in concert with their buddy G, and they shot up the neighborhood, and that's it. But see, they all acted guilty. They all left, and then they came back lying, and they've come in here lying. Well, it was the police. Oh, then it's the white van. And then, it's Mr. Jarvis. He's the reason why, my clients, why we're charged with this thing we shouldn't be charged. And then it's the former attorney's fault. Now it's the former attorney's fault. Now it's violent society and social media. If there were a real defense, they would say it at the outset, and you would hear it again and again and again, and it would be the real defense. It'd be the real deal, they would say it. But it's all these different things. It's somebody else. Somebody else's fault. Somebody else. It's that person over there. It's society. It's all these other people except these two. And they're the ones out there with the guns, admittedly shooting, and they really don't have a good reason for it. Because it's malice murder. It's felony murder. They're committing aggravated assaults, and they're also committing felony murder based on criminal damage to property. Acting in concert as parties to the same crime together with G. The judge is going to tell you that intent can be inferred from the proven circumstances or by acts and conduct, or inferred when it's a natural and necessary consequence of the act. You shoot a gun in a neighborhood like this, with all these kids and teenagers and people around, you are intending the natural consequences of those bullets flying everywhere and maybe hitting an innocent bystander like it did in this case. And it is shameful, that the whole thing is shameful, that an innocent man lost his life because these two, like Detective Thorpe said, they just wanted to act a fool. They just wanted to bust off some rounds. That's just really what this is all about. You can consider their intent, consideration of words, conduct, demeanor, motive, and other circumstances connected with the act. Do not concern yourself with the guilt or innocence of the defendant, or you are only concerned with the guilt and innocence of the defendant, not punishment. And you're gonna have two documents that are key to this case. One is the indictment that I've been talking about, and the judge is going to give you a verdict form. And it's going to be to each defendant. So you will decide for those 6 counts on Mr. Phillips, and then separately for Mr. Parks. There'll be a verdict form that the judge will explain. These 2 defendants are guilty. You can rely on the witnesses and the evidence. This is not a self-defense case. There is nothing, no proof, no credible evidence or testimony at all that indicates that this is a self-defense case. Just like Detective Thorpe said, this was an opportunity that they used to just bust off a few rounds, a bunch of rounds, in this case, 31 rounds, in a neighborhood with no justifiable reason. That's malice murder. They were parties to the crime, and because they were acting in a conspiracy, which is just an agreement, doesn't have to be a verbal agreement, but an agreement among 2 or more people to commit a crime, one person's act loops them all in. Kind of like a football game, the kicker kicks the winning field goal, but the whole team wins. Or the kicker misses and the whole team loses. 2 final thoughts. There's a lot of concern in our society about violent crime and gun violence. A lot of people talk in jury selection about what can we do? Violent crime, nobody likes it. We got problems and problems and problems with violent crime. This is an opportunity. You may not be able to stand on the Senate floor and propose a bill or some legislation to fight violent crime, but you're on a jury right now in which there was an innocent person killed, and you got the 2 defendants doing most of the shooting right here in front of you. And it's been proven beyond a reasonable doubt. The final thought is that Tavius Arnold, the deceased victim, is not the only victim. Every one of those people in that neighborhood were victims. Any one of them could have gotten shot and killed. Any one of them. Miss Neal, who was standing right next to Tobias, had twins at the time. This could have been the kind of story that made nationwide news, and it didn't. And that's so good. But let's not forget that our community is a victim. And these 2 are the wrongdoers. When you find them guilty beyond a reasonable doubt, you're not telling them anything they don't already know. They've sat here this whole trial, and they have known that they are guilty beyond a reasonable doubt. And I respectfully ask that you find them guilty on each and every count on the indictment. Thank you.
Thank you, Mr. Greiner. We actually have time for me to give you the jury charge as well. I'm gonna have you just sort of move about a little bit before I do that. So stand up if you need to. If someone has to use the restroom, go use it, but we're not taking an official break. So just if you need it, shove by your colleagues, get in there. And it's my turn to have something up on the screen. We're still missing one. You guys can, I'm standing because I've been sitting for a while. You're welcome to stay standing, it's not required. Make sure no one got stuck. Thanks. They're just in there eating the snacks. Get them all to themselves. All right, Ms. Rivers, you ready? Here we go. So, ladies and gentlemen, we've reached the point in the trial where I will be giving you what's called the jury charge. It's the law that I give you that you must apply to the facts as you find them to be. I'll tell you a couple things about the charge. Most important, you will have this document with you during your deliberations. I'll be reading from this pretty close to verbatim. So you're welcome to take notes. There's a fair amount of legalese in here because it's the law. And there are several concepts that I'm required by higher court opinions or by statute to describe in a way that may seem to you like fairly stilted in the language. It's not how I normally talk. It's not how you normally talk. But you've already heard one of the phrases, an abandoned and malignant heart. People don't talk that way. But that's a term that's used when talking about the law around the crime of murder. So I try to make this as accessible as possible. That doesn't make it exciting, but it's meant to make it accessible. I'll be reading it. What I read will also be on the screen. So if you're someone who likes to read along with what you're hearing, it'll be on the screen and you're welcome to take notes. But again, this document is part of, it's not evidence, but it's part of the record that goes back with you, just like the indictment, which is not evidence, will go back with you during your deliberations. And if you need additional copies of the charge, I can get that for you. With that, a grand jury has indicted the defendants for murder, felony murder, aggravated assault, criminal damage to property, and possession of a firearm during the commission of a felony. The defendants have entered pleas of not guilty to these charges. Neither the indictment nor the pleas of not guilty are evidence. And I'm going to remind you, it's not on the screen. There are two other charges in the indictment. You're going to see them. They relate to Carrie Henderson. You never met her. And her charges and her situation are not before you. Simply Mr. Phillips and Mr. Parks. The defendants are presumed innocent. This presumption remains with them unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that one or both defendants are guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. There is no burden of proof upon the defendants, and the burden never shifts to them. If a defense is raised by the evidence, the burden is on the state to disprove or negate that defense beyond a reasonable doubt. The state is not, however, required to prove either defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. It is a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. That reason arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if that doubt does not exist as to a defendant's guilt, you would be authorized to convict. Evidence that merely places upon a defendant grave suspicion of the crimes charged, or that merely raises a speculation about guilt, is not sufficient to convict. It is my responsibility to instruct you on the law. That's what's happening right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence that's been presented. You must then apply the law I'm giving you to the facts you find. You must decide this case based only on the evidence presented here during trial. That evidence consists of witness testimony and the exhibits that have been admitted. Evidence does not include the indictment or the pleas of not guilty, anything said by me or any of the lawyers to include their opening and closing remarks, nor does evidence include any questions posed. And that would include a question that you submitted but wasn't asked. That's not evidence. That was something not presented to a witness, and more importantly, a witness never said anything in response to it. Now, the evidence you've received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I was standing right there and the car went through the intersection when the light was red. I saw it. That's an eyewitness. That would be direct evidence that a car ran a red light. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. For example, if people walked into the courtroom right now with umbrellas and their jackets were wet, that would be circumstantial evidence that it's raining out. You can't tell if it's raining. No windows here. I think it is raining, but we don't know that for sure. But circumstantial evidence would be umbrellas and people shaking water off themselves, things like that. There's no legal difference in the weight you may give direct or circumstantial evidence. And in considering this evidence, you're free to use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. In doing this, you must, turn the page too soon, determine the credibility of the witnesses. In deciding this, and credibility means believability, you may consider the evidence, the witness's manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of the case. You may also consider any possible motive in testifying, to include pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony to statements that he or she made before this trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You have heard from several expert witnesses. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to you or me, the average person. Experts are permitted to give their opinions based upon that training and experience. However, the testimony of an expert, like that of all the other witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is generally not required, provided you find that witness's testimony to be sufficient. A defendant who has no burden to prove anything is not obligated to testify. Where, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. A statement that a defendant allegedly made while in custody has been admitted. Before you consider this as evidence for any purpose, you must determine whether that defendant's statement was voluntary and whether the defendant was properly advised of his constitutional rights. The state must prove the identity of the persons who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for that purpose. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendants are not presumed to have acted with criminal intent, but you may find such intent, or the absence of it, from consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendants are being prosecuted. If a defendant intentionally commits an unlawful act and his act harms a victim other than the intended one, it is not a defense that the defendant did not intend to harm the person who was actually injured or killed. No person should be found guilty of any crime committed by accident. If you find that the incident that is the subject matter of this case occurred as a result of accident and not as a result of a criminal undertaking or criminal negligence, then it would be your duty to acquit the defendants. Every party to a crime may be charged with and convicted of a crime. A person is a party to a crime if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, or 3, intentionally advises or encourages another to commit the crime. Any party to a crime who did not directly commit the crime may nonetheless be prosecuted for the crime upon proof that that crime was committed and that the person was a party to it, even though the person who may have directly committed the crime has not been prosecuted. You may not find a defendant who was merely present at the scene of a crime at the time it occurred guilty of the crime unless the evidence shows, beyond a reasonable doubt, that the defendant committed the crime, helped others to do so, or otherwise was a party to the crime. Similarly, you may not find a defendant who merely associated with others involved in the commission of a crime guilty of that crime unless the evidence shows, beyond a reasonable doubt, that that defendant helped in the perpetration of the crime or otherwise was a party to that crime. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. A defendant engages in a conspiracy to commit a crime when he, together with one or more others, agrees to commit a crime and one or more members of that group does any act to bring about the object of the conspiracy. And a conspiracy is simply an agreement between two or more people to do an unlawful thing. The existence of a conspiracy may be proven by conduct as well as by proof of some express agreement. When people associate together in an unlawful enterprise, any act done by one co-conspirator to further that conspiracy is legally the act of all the conspirators. However, each person is responsible for the acts of others only insofar as those acts are done to further the conspiracy. You may consider presence, companionship, and conduct both before and after the commission of the alleged crimes in determining the existence of a conspiracy. Murder. For murder, the state must prove that a defendant, number one, caused the death of another person, two, that he did so unlawfully, and three, that it was done with malice aforethought. The killing must have been done with malice to be murder. But malice, as that word is used here in this narrow context, does not necessarily mean ill will or hatred. Rather, it is simply the unlawful intent to kill. You may find malice when the circumstances show that a defendant acted with the deliberate intention to take the life of another. You may also find malice when there does not appear to be significant provocation and the circumstances of the killing show what we call an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, that is, with unlawful intent, it is a murder regardless of how briefly that malicious intent existed. No specific length of time is required for malice or intent to arise in the defendant's mind. That malice or intent may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act that killed, and it moved him to do it, that is enough for the killing to be murder. Proof of motive is not essential to the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the time of the killing. Felony murder. For felony murder, the state must prove that a defendant, number one, caused the death of another person, two, by committing a felony. The state does not have to show that the defendant acted with malice, that is, with the unlawful intent to kill, in order to prove felony murder. Aggravated assault, which I'll define in a moment, and criminal damage to property, which I will also define, are both felonies. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing the felony of aggravated assault or criminal damage to property, regardless of whether he intended the death to occur. There must, however, be some causal connection between that felony, aggravated assault or criminal damage to property, between that felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after that other felony was committed. That felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Now, in considering the malice murder and felony murder charges, you must decide if the defendants were sufficiently provoked and acted out of passion. If you find this, you may not return a verdict of guilty of murder or felony murder, but you would be authorized to return a verdict of guilty of voluntary manslaughter. The state must prove beyond a reasonable doubt that the defense of murder should not be reduced to voluntary manslaughter. For voluntary manslaughter, the evidence must show that a defendant, number one, caused the death of another person, two, under circumstances that would otherwise be murder, three, that the defendant acted only because of a sudden, violent, and irresistible passion that resulted from some serious provocation, which was sufficient to excite such passion in a reasonable person. If you decide that enough time passed between this provocation and the killing for a reasonable person to have cooled off and regained judgment, the killing is not voluntary manslaughter. We'll talk about justification, which is self-defense, defense of others. Sometimes a defendant's use of force is legally justified and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury only when, 1, he believes that the use of such force is necessary, 2, to prevent death or serious bodily injury to himself or a third person, and 3, a reasonable person would also find that the use of force was necessary. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you find that the defendant's actions in this case were justified, it would be your duty to find them not guilty. A defendant is not justified in using force if he provokes the threat or use of force against himself, intending to use that threat as an excuse to harm the other person, or if the defendant is committing or fleeing after committing a felony. Aggravated assault is a felony, which I will define for you on the very next page. A person commits an assault when he attempts to commit a violent injury to another. A person commits aggravated assault when he assaults another with a deadly weapon. And I'm telling you that a firearm is a deadly weapon. Criminal damage to property. A person commits the offense of criminal damage to property when he knowingly and without authority interferes with the property that is alleged in the indictment in a manner so as to endanger human life. A person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. Murder, felony murder, aggravated assault, and criminal damage to property are all felonies, and the idea of firearm includes any handgun. In the jury room, ladies and gentlemen, you will have these 2 verdict forms, one for each defendant. One has Mr. Phillips's name on it, one has Mr. Parks. You should consider each count individually as to each defendant. Each defendant may separately be found guilty of some, all, or none of these charges. If, after considering the evidence, together with the instructions I'm giving you, which are almost done, you should unanimously find beyond a reasonable doubt that one or both defendants did commit here in Fulton County any of the crimes alleged in the indictment, you would be authorized to find that defendant or those defendants guilty. And in that event, the form of your verdict would be, we find defendant X, whichever one it is, guilty. And you would check that option on the verdict form for that defendant. If, however, you do not believe that a defendant is guilty of a particular offense, or if you have any reasonable doubt as to that defendant's guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find defendant X, Parks or Phillips, not guilty. And you would check that option on the verdict form for that offense for that defendant. Whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing, that's why we have the verdict form, and signed and dated by your foreperson. I have on the screen now a little excerpt from the verdict form, and I'm putting it up there to emphasize one point. For murder and for felony murder, you're going to have 3 options, not 2. For all the other felonies, you'll have guilty or not guilty. But for murder and felony murder, guilty of murder, guilty of voluntary manslaughter, or not guilty. Check one. Don't check more, or none if you can't reach a verdict, but don't check more than one. And that instruction is at the top of the verdict form. But your verdict would be as to one of the options for each of the counts. Ladies and gentlemen, by no ruling or comment that I have made during this trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of either defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws I have given you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that one of your colleagues is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You decide what happened here. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs back in the jury room will be to select a foreperson who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with all of your fellow jurors and after a careful consideration of all of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any research. I've told you that a bunch of times. You have all the evidence you're going to get in this case. It would be improper to supplement it with any outside information. And to assist you in complying with these instructions, Deputy Gordon will be collecting all of your electronic devices, including smartwatches, during your deliberations. You get them back every time you leave, but while you're in the jury room deliberating, your devices make their noises back in my office. Going forward, should you need to communicate with me for any reason, it must be in writing. And upon receipt of your question, note, concern, query, whatever it is, I will confer with the parties and share with you whatever response I am allowed by law to give. And that last proviso is important. You may have a great question, and my answer may be, you have to rely on your recollection. Hey, what did that guy say? I don't get to answer that for you. I may remember, I think, what the person said, but that's why you took notes. That's why there are 12 of you. You will collectively develop your recall of what that guy said. And so sometimes my answer may be, you're going to have to rely on your collective recollection. And that's not me being glib. That is the proper legal response to a question that gets into, well, what was the evidence? Other times I'm able to say, here's your answer. But I will respond whatever the question may be. With that, we have completed the legal instructions I need to give you, and we are at just about 5 o'clock. We need to talk about logistics. You all told me yesterday you couldn't stay late today. I'm going to check again if that's still true, because if it's not true, then you could start your deliberations. But we need to figure that out, and we also need to figure out who all can still be here after today, because some people have conflicts after today. So I don't know if you all want to talk about it again, or if there are, it only needs to be one. If there's one hard and fast, I need to leave around 5, then we're done for the day. So do you want to talk as a group first, or do we already have an answer? Sir.
Question. I have my flight to Friday, so I can be here.
Okay. That's good to know. We may not be able to be here tomorrow. The chief judge is mulling over whether the courthouse will be open for non-emergency matters. And I sent him an email saying, this is an important trial. And he asked, is it an emergency trial? I said, I don't think there is such a thing. So we're working through that. But if the right answer is that you should be in the safety of your own homes, or your employer may say, you're expendable, come to work, then you may have a day off tomorrow. So I very much appreciate what you did, but it might be that we reconvene on Friday and not today, and we'll have to figure out what you're going to do about that. But the immediate question is whether you all want to start your deliberations this evening to see where you get. And we can stay, meaning the lawyers and Deputy Gordon and the parties and I can stay till whenever. That's not to say I'll keep you here. Once deliberations begin, you run the clock. But you may decide, hey, let's be here for a couple hours and see where we get. And I want to give you that opportunity. You may also say, it's been a long day. Actually, it's been a short day because we didn't start till 1, but you have your own lives. So do you want to talk as a group first to figure out what you're going to do? Or again, is there someone who knows he or she needs to leave now and we burnt past the end of the candle?
Have a question.
Yes, ma'am.
If I decide to stay, so I don't have to, I'm done today or have to come back on Friday?
So two things. One, I'm putting no pressure on anyone to do anything today. If people want to leave right now, that's fine. Before you leave, I'll get the final answer about whether we're coming back tomorrow or Friday. I don't want to create a crisis with my chief and say, you're not my boss and we're going to be here anyway. More importantly, I don't want to have you guys driving around when the weather is funky. Right now it's just raining. There was apparently a little lightning, but we're big kids and can drive through lightning. But at some point there may be some bad winds and it may be safer for people not to be driving. Again, this would be the safest place to be. What you really should do is ask me to bring in 13 cots and a bunch of pizza and we just stay here and spend the night. Because then we didn't leave. We haven't violated the judge's order because we didn't leave. And we'll have power. There's uninterruptible power in this building. But I'm not going to do that to you guys either. So that's this, the weather has created that additional complicating factor that even though the lawyers blew past their time estimates, no one knew Helene was coming. But Helene is coming. Right now it's pre-Helene, and so it's a little wet. But Helene could always veer into Alabama and this and that, but we're just trying to be thoughtful about that. So how about this? I've laid a lot on you. Why don't the 13 of you go into the jury room, talk for 3 minutes, and then let Deputy Gordon know what the plan is?
All right, good.
Mr. Rowe, will you please grab the two verdict forms and read them yourself and share them with the other lawyers? Thank you. So we have a set of variables that looks like the first page of Mr. Menendez's closing right now. As in, what are we doing today? Are we meeting tomorrow? And I haven't even told the alternate that he's the alternate yet, because he may not be the alternate if we're losing our other juror who added a new variable that he changed his flight because he wanted to be here tomorrow to conscientiously serve. And that gentleman is not the alternate. Alternate is the juror with the green shirt. That's what we all agreed. But he's not the alternate if gentleman who changed his flight cannot change his flight from Friday. So many balls in the air. I'm going to just keep us focused on what we can control, and that is please look at the verdict forms and let me know if you have any issues with the verdict forms. And by the way, they're identical. So if you like Parks, you like Phillips. They just have different names.
Judge, one thing that's not in the verdict form, I wanted to mention that we have two, out of all these exhibits, there were two that don't have the nice, pretty red exhibit sticker at the bottom. These are 26 and 27. So we've reprinted them and I've marked them with the stickers. I just want my colleagues to look at this.
Okay, but they're the same exhibits. You just reprinted them.
Yes, Your Honor.
Okay.
Just let y'all look at that, and if we all agree, then we'll put those into the record.
Okay. While they're looking at that, you look at the verdict form, please.
Your Honor, I don't have any objection to State Exhibit 26 nor 27.
You said you have no objection to.
Correct, Your Honor.
Okay, show them to Mr. Rowe. I'm confused. I don't have a 26 or 27. They were, well, I do. They were part of 24 through 56. So these are crime scene markers. There just was something funny about the labels on them.
No, we just don't have them here for some reason.
Oh.
They got lost.
Okay.
It happens.
All right.
Your Honor, my only concern.
Before you get to that, right now we're on, you're okay. It's 26 and 27. They just have labels now. All right. Please put them, Ms. Porter, wherever they go numerically. You're our numeratician. It's a word I just invented. All right. Mr. Greiner, you're concerned about the verdict forms.
Judge, count 3, and I may be wrong, but this looks like to me that count 1 and 2 provide the option for voluntary manslaughter, count 3 is also felony murder is not.
Right, because it's not based on aggravated assault. Count 3 is premised on criminal damage to property, and that there's not the building didn't threaten anyone. And so I don't think that voluntary manslaughter applies there. I recently had, actually, this verdict form I was able to borrow exactly from a situation where someone shot at someone and shot up his car as well. The car it wasn't a situation where someone tried to run him down with a car. He claims the guy shot at him first, and so he shot back. But that he had been provoked. So it was self-defense and it was potentially voluntary manslaughter. That affects the aggravated assault, the felony murder predicated on the aggravated assault, and obviously malice murder. All the things that merge or vacate in your standard murder train. But I don't believe that voluntary manslaughter would affect the criminal damage to property because the building didn't provoke anyone. There's a specific building named. Mr. Menendez has pointed that out. That's the property that has to have been at issue. And I don't see how that serves as the provocation for the voluntary manslaughter.
I understand, just want to make sure that we have that.
No, okay, appreciate you flagging that. All right. We're going to hear from the juror. Well, what did the jurors have to say? They want to go.
I was just messing with us. They were saying tonight.
All right. So my thought is then that I want to find out from, it's actually juror 39 is his number, what his situation is about being able to be here on Friday. Mr. Griner, do you have any objection if I bring him out to ask him about his flexibility?
No, Your Honor.
Mr. Menendez?
No, Judge, I just imagine the court's gonna probably go into if you can move it this time, why not move it again?
I'm gonna ask him, I'm very impressed and flattered for the process that he moved it. And so of course I'm gonna ask him that because we're reconvening on Friday. I've been told we can't tomorrow, and I'm assuming you don't want to do Zoom deliberations. Any objection if I engage juror 39 briefly on his Friday availability? No. All right, if you could tell them to sit tight and then have 39 come out. I know. Hey, you just take a seat, please. First, thank you for changing your schedule. I didn't write notes down because you said it's not a conflict. I know you flagged it. Is a wedding or something you're going to? Family. Okay, whatever it is, you have plans. The reality with this weather is that tomorrow we cannot reconvene. The hope is that if I pound on the chief judge enough, he'll reopen the courthouse on Friday, so 9 a.m. or whenever the group agrees, we'd reconvene and you'd literally start your deliberations then. The evidence would be in there, videos would be ready, but that's Friday. I need to know your availability for Friday.
Currently, I'm scheduled to be on a flight at 7:45 p.m.
Oh, okay. Out of Hartsfield. Okay. So if you were able to serve and there's a resolution by noon, there's no pressure on you. If there's not by when we would naturally break for lunch, then I may need to talk with the lawyers because it's not fair to anyone involved if you feel a clock ticking. But it takes 12, and if 12 people decide what they're going to do before I believe you'd be realistically feeling that clock ticking, then I'd like you to remain on the jury. And this is all assuming we are able to reconvene on Friday. If Helene knocks this building over, then we aren't on Friday, and we've got everyone's email and phone number, and hopefully you'll be able to get out of town on Friday. There's that we hope for you as well. Will you come to the courthouse ready to go to the airport so that you don't need to go home first? That'd be great. I'd appreciate that. What I'm going to do is have in a moment everyone come out. I'm going to give writ large operating instructions, which is people should assume they're coming back on Friday, but we'll be contacting everyone if that changes. Okay? I really appreciate your flexibility. If you go back there, and I like your socks.
Thank you.
pumpkin socks. Mr. Griner, you understand my plan. I'm gonna tell the jurors they have tomorrow off. They should assume they're coming back Friday, 9 AM or whatever time they can agree on the start time. They may say because the commute's 10 works better. And then we'll be contacting everyone, to include the lawyers, if we don't have the green light to be back on Friday. Any issues with that?
No, Your Honor.
All right, Mr. Monetis, any issues with that plan or counter suggestions?
I was wondering, is the plan that the juror would come back on Monday? Okay, I'm confused with it.
Who would come back on Monday?
This flight that he's gonna leave on at 7:45, is his plan to average verdict by the end of the day to come back to deliberate on?
I don't even ask when he's coming back. So they deliberate, they say, we want to stop at 5, or I tell them they're stopping at 5. So we're not creating that pressure for him. They don't need to know why I say we stop at 5. We need to make sure he could be back on Monday, because then he's still part of the jury. I hadn't thought about that. I'll fix that in a minute, as in we'll find out what the answer is. But otherwise, do you have any issues with or counter suggestions to the plan that I described?
I do have a bit of a concern about what the court mentioned about just the nature of knowing or having some kind of subconscious pressure that you gotta decide by a certain time if he's on the fence.
Sure. And that's going to exist on a Friday for all the jurors. They all want to go home and they don't want to come back. So I actually, given how late his flight is, I find right now that is an understandable, but right now negligible worry. The later in the day it goes on Friday, the more that becomes realistic, which is why I may well, after consulting with all of you, send Deputy Gordon in there to say, hey, how close are you? And if they say we need a bunch more hours, hey, something came up, it's 3 o'clock, you got to go home. So we just take that off the radar as a possible concern. Or there's always the plan B, we have an alternate. His alternate will be here. And so if the jurors say we're close, but it's 5, then we may have to excuse him. Of course, they have to restart their deliberations, but then we put in the alternate.
Right, and I guess that would make this, would he know that? Because I don't want him to think, oh, I better,
Would he know what?
that if there's no decision by 5, that he's gonna be excused in the alternate.
I don't tell the jurors that. I don't want any juror to know that, because a different juror could say, great. And then they go home because there's an alternate there.
Right, Judge, that's my worry, is like, I know there's the typical traditional pressure of a Friday, but if he knows he's not coming back from Monday, or if he knows he's gonna be, there's a quarter option,
So I understand you to be worrying about things, and you've been paid to worry about things. And I hear you, and you're making that record. For now, the plan is to have all 13 come back Friday morning. It may be moot if we can't come back Friday morning, if we cannot. And then we'll see who's around on Monday. But I do need to find out, appreciate you flagging that, from juror 39. Hey, when do you come back? Because if it's Sunday night, we're good. Assuming we don't lose other jurors on Monday. This is super frustrating. It's no one's fault but Mother Nature and global warming. So if you don't drive an electric vehicle, I blame all of you. But we've got a big storm coming, and maybe 7 jurors say, well, you didn't ask me what I'm doing the following week. We're all going to France on the same private jet that we've already paid for.
We can recess, Judge, I guess, yeah, that's the main question, is if he's not coming back Monday, then I think the concerns that the court and I talked about would be more.
Okay.
Concerned that if he's coming back, of course, Sunday night.
2 bridges to cross. 1, are we even meeting on Friday? And then 2, how long does it go? If we get a verdict in 2 hours, so not there yet. Mr. Rowe, any concerns with or suggestions for a plan beyond what we did?
Yeah, I actually think it just, I don't think any concerns unless he's not coming back on Monday. That's the only thing.
Okay.
I would say, other than that, that's
Got it. Can you ask juror 39 when he's coming back? They're staying late after all. They can all come in. Best juror ever.
All rise for the jury.
Great. So here's the plan. I just looked at the additional back and forth. Several of my colleagues are blown up with the chief judge, but he's the one who's been talking with the FEMA type people. And so we are closed tomorrow. We should assume that we start deliberations, you start deliberations Friday. I need to know what time you'd like to be here Friday. Now that we're deliberating, we run on your schedule. And so you may say, hey, if we can start at 9:30, I missed my commute could be 20 minutes down here instead of 2 hours. The default is be here by 9. All of you need to be here. We can't start deliberations if someone isn't going to be here. And so my proposal is be here at 9 on Friday, but it's your deliberations, not theirs or mine. Is there a different time you'd like to start? Hearing none, here's the plan. 9 a.m. on Friday, report like you do, go to the jury room. When all of you are here, we'll bring you the evidence and you can start your deliberations. Until then, don't talk about the case, even though there may be 10 of you in the room, you're just at ease. Now, we will contact you if the courthouse is going to be closed on Friday. So keep channels of communication open. Check your email because we'll email you and we'll also call you, my staff and I. And you should feel free to call Chambers. I think that number's up there. That's 6907. Call it at 4 in the afternoon. Only 13 of you, so we can handle that level. It doesn't work when there's all 60 potential jurors. If I learn at 10 tomorrow that the courthouse will not be open Friday, we'll push that information out. But the chief judge is being leaned on pretty hard. There are other juries deliberating. There's someone in the middle of a med mal trial that's been going on for 2 weeks. Like, what? We're stopping now? So there's a lot of pressure to be open on Friday if it's safe. But that's what we'll control is the safety, your ability to get down here. Let us know if something comes up in your life, but I'm assuming all of you can be here. So the roads are open at 9 on Friday. And then it's deliberation time. If I have the case, you'll figure out what the answer is, if there's an answer in this case. Any logistical questions from anyone? No? Tomorrow is your day. I don't know that you'll get your $25 as a juror, but you're still a juror. I'm hoping your offices aren't open. If our courthouse isn't open, most places better be closed because we're supposed to be one of the last things that closes. And we're closing. So don't talk about the case with others tomorrow. It's not a free day to research. In fact, this is the worst possible time now because you're at the edge of beginning to consider and talk about it with your colleagues. This is what you've been waiting for and everyone else has been waiting for. So tomorrow is a day of rejuvenation and refreshment, but not working on this case. All right. I very much appreciate your tolerance and patience in this case. If I could apply for bonus juror funds based on what you've been doing, I would do that. I know this is a financial hardship for some of you. Tomorrow, play the lottery a lot and win $100,000, and that will defray the expenses you've incurred while being here. I won't keep you here any longer. Oh, I don't know what the weather's like. Is there a way we can help get them somewhere so they don't get super wet? You have a lot of extra umbrellas?
I don't think it's raining right now.
Okay, well, this is the perfect time to leave. All right, we'll be in touch, but the default is we see you Friday at 9.
All right, jurors.
So Judge Emerson got a verdict about 5 minutes ago. Yeah, they did not deliberate long. This was all on video. Mr. Griner, anything we need to cover before we break for the day?
No, Your Honor, we've got all the evidence in order. We're gonna provide it to the court and, nothing else, nothing further. We do have the demonstrative 1A, but all that'll just be up there.
Okay. If I'm able to have the jury be here on Friday, one of you will need to be here. Your boss is a little more permissive in they may be protesting somewhere else, go home for the day. So I don't require both of you to be here, but if the jury's going to be here, we'll need an ADA familiar with the case available to be in court for verdict, juror questions, whatever we might have.
Yes, Your Honor, I'll be here.
Okay, and I'll let everyone know what the plan is. Mr. Monetis, anything we need to talk about before we break?
Yeah, I don't think there was any continuing witness exhibits like written.
I'm gonna ask about that in a second. I very much want to do that. I just wanted to know if you all had other beyond, are we okay with what's in the postal service box?
No, Judge, so we'll be here on Friday night.
Unless you hear otherwise, right? I'll probably send an email anyway saying we're good to go. I definitely will send something if we're not good to go, so you don't try to paddle down here if the courthouse is closed.
Yes, and then the phone number on my filing is my cell phone number. When I
Okay.
pass it on your call.
All right, I'll be emailing the lawyers. Mr. Rowe, anything else? You can sit if you want. We're gonna talk for just 2 minutes.
No, Judge.
You're good? Okay. Before the lawyers leave, I need to know that everyone is okay with what's in that box as what goes back with the jury. I will put in it the verdict forms, the jury charge, and the indictment. That will be my contribution to it. But I want both Mr. Monetis and Mr. Rowe to flip through there. I'm not aware of continuing witness issues either. Sometimes a lawyer will say, well, the medical examiner's report. In this case, you're free to make that objection, but there you are. Now, you just handed back to Mr. Monetis the shell casing photo, but that's it. Is that an extra copy of it?
No, I didn't. I wanted them to have opportunity to inspect it before it goes in the box.
I'll expect.
Hold on, this never rings. Hello? I don't want any fried rice, thank you. It's odd. That should be part of evidence, I believe.
Of course.
Okay. You weren't suggesting, you're just saying, hey, that's not our exhibit.
Exactly.
Want to know what you want to do with it.
Yes.
Okay. So Philip, I think that's Phillips 2.
It's around, it's Phillips D3 and Phillips D2.
Remind me what's on the thumb drive.
2 is on the thumb drive.
Oh, what's on the thumb drive though?
Oh,
that's the video you made.
Yeah.
Okay.
Video.
Both go in. And then what you have, I believe, Mr. Rowe, would be Ms. Blakeney's report,
Right.
which we're making part of the record.
Right.
That does not go back with the jury. We all agree on that. Okay.
So where do we put the items that that's there?
Ms. Rivers, she will manage that. The other thing I need to figure out is what videos are in and where I find them, because I need to put them on the machine in the jury room that will have only that and a video player. Don't have anything else, but I actually plug a thumb drive into it. So can we just talk about what exhibit numbers those are, and I will take care of that.
Exhibit number 3 are the 2 911 calls that are on the thumb drive.
Okay, so states 3.
States 16 through 21 are videos on the thumb drive.
Okay, and there's a single thumb drive that has all of them on it.
No, Your Honor.
It's multiple thumb drives?
Multiple thumb drives.
One for each?
I'm sorry.
Because Mr. Monetis had been talking about one thumb drive, but multiple file names on it.
That's how it is. Yeah, it's actually a bit confusing when I was looking at it. It's like the only one I had personal experience of was it said 16 through 21 on it, but then there seemed to be more than 5 videos on there. No, I was manipulating the 6 or 7 videos. So I can say I was.
You gave the file names, it was clear. I mean, you made the right record.
But I'm just telling the court that it's not it's not like it's labeled, it's not 5, it's labeled 16 through 21, but there's way more, not way more, there's more than 5.
So I'm gonna task you on, you can do this remotely, you don't need to be in the office for this, but I need you, state, to create a file that is 16, a file that is that corresponds to what was played in evidence. I appreciate that the file name on the thumb drive might say MOV 41236. That native file name we can get rid of for purposes of what will be on the machine. What's on the machine in there isn't the actual evidence, it's a copy of it, but the jurors will be endlessly confused if it has that native file name. And so one of the two of you, if you could create a video, is not create, just make a copy and rename it, that says Exhibit 16, Exhibit 17, that corresponds with each of the whatever 16 through 20, I actually have through 23 because there were some from Teague as well. That may be on a different.
It's all in one thumb drive?
Yes, that would be beautiful. And if you would add to it, I believe, unless it was the late discovered video, meaning the one Ms. Stallworth provided, was that part of 16 through 23? Oh yeah, because she got all of them in.
Yes.
Okay, so if you would please, whether you email me or you get me a thumb drive, I guess the easiest would be when we all get together on Friday. There's no point, I can't do it tomorrow. So if you could bring to court, Ms. Porter, whether it's Friday or Monday, whenever we next meet, a thumb drive that has on it 16 through 23 with the files actually labeled that, Exhibit 16, Exhibit 17. Then Mr. Monetis, you only have one file on your thumb drive, so that's easy. That's the one that you created here in court.
Correct, Your Honor.
Okay. Were there other videos? I don't mean to omit, and then there'll be the phone call. So if you put the 2 911 calls on that thumb drive as well. So what's on States 3, so it's all the digital evidence. Was there, other than photos, because technically that was digital, but you've got hard copies of the photos, were there any other audio or video files that the state got into evidence?
Yes, Your Honor. 3, 16 through 21, as well as 22 and 23.
Yep.
26 through 27, 62.
So pause for a moment. 26 and 27.
I apologize. That was the crime scene photo.
Right. Okay.
62, which is the body worn camera of Officer
Carter?
and then 156 is Parks redacted.
Yes. Yes. Thank you. So all those things.
So, Judge, I just want to make one observation. If I'm not wrong, don't we have a bunch of folks on this? Okay, all right, never mind.
Okay.
Thank you.
Yep. So let me, with a different colored pen, circle it for mine so we can double check. So, Carter body cam, which is 62. Mr. Parks's interview, 156. And then 16, 17, 18, 19, 20, 21. 2, 3. And then 911 calls. Okay. So Ms. Porter, that would be a huge help. If you could have that thumb drive, and then we've got the one from Mr. Monetis, but that's on a thumb drive. So that's easy to do. Okay, that covered what I wanted to cover. Anything else from the state?
There you are.
Unfortunately, we gave Mr. Monetis time to go through the evidence. He seems to have been poring over a document. Is there now a concern you'd like to raise?
Yeah, Judge, I'm not sure, I guess I want some insight from the court. Normally the police reports don't go back.
Agreed. What report is there?
There's the crime scene sketch, which of course goes back, but it's, I'm realizing now for the first.
What exhibit number are we talking about?
63.
Yes.
Okay, this is from Investigator Fall, and I think a few pages were of the actual measurements made. Is there some kind of narrative that you think is testimonial, or is it simply where he has the measurements from evidence placard 2 to A and B.
I guess, nothing maybe not testimonial, Your Honor, but it is a police report. I guess it's nothing different.
I know that gives you the hives, but I don't think it's testimonial. I'm gonna allow 63. If it is limited to a cover sheet plus those charts or tables that indicated the measurements that were made, so it's data, and then the map that was produced therefrom. I don't believe any of that is continuing witness because it's not the testimony. There was testimony about it. That's not going back with the jury.
Yes, so police report.
I can tell you're the hair on the back of your neck is sticking out.
Yeah.
What is it? Power and persistence, all that stuff.
Judge, I have one that's concerned about as well.
What exhibit number?
3A.
Okay.
It has, I think it's maybe a CAD report, I'm not sure. Yeah, CAD report, but it has statements on it. Yeah, it has statements as to explaining.
Give me an example, because if it says it's raining, I don't know that that's, what's an example that gives you concern?
September 13th, return call Carrie, Brother Carrie Henderson wants to speak with police department, but did not where she will be waiting no further. So still, it's like giving statements as to what occurred. I mean, it's like continual testimony. To me, it's similar to that.
Okay. Mr. Greiner, your thoughts about the CAD report? I think parts of it go to the jury no matter what. And so we may have to redact if it looks like an operator was summarizing a statement that someone gave or describing what Ms. Henderson said or didn't say. But all the other stuff about the time of the call and this and that, that's also data recorded, and much like measurements, I think goes out with the jury.
I don't disagree. If there's a statement there that's a summary, we can look at it, just redact.
All right, why don't we do this so we don't keep folks here at a time when I understand why they'd want to get home. If you would come up with a redacted version, and well, I guess you don't know what is concerning. So I'm going to leave it with Mr. Rowe. You should email Mr. Greiner and Ms. Porter, obviously copying Mr. Menettis, the parts that you think ought to be redacted from States 3A, the CAD report. And then if I need to referee it on Friday, hopefully, or Monday, if necessary, I'm glad to do that. But it literally could use the white tape and then re-photocopy it. I don't mean for it to be sophisticated redactions.
Judge, the one thing I wanted to make sure that be excluded from what goes back to the jury were Mr. Jarvis's notes. I want to make sure that we don't make a mistake there.
Okay, well, if that, I would assume that Mr. Menettis with his eyes closed could reach into the pile of exhibits and pull it out. But there's a giant stack of papers there. I don't know what's in it. It is.
I'm just saying for the record that I want to make sure.
You are making all good efforts to keep it out. 193A.
193 goes back, 193A does not. And so I think we can put this over here, I'm gonna put 193 over here with D1 parts.
Okay,
Something that does not go back,
all right,
but my colleagues can do it.
all right.
Your Honor, I will, the more I'm looking at this, it says supplement, it's in report stated at 63. And it doesn't have like sentences, but it is a report, it's labeled as a report.
Okay, just state your objection.
That's it's a report.
Okay.
What we did, what we would admit is the sketch has the same information. It's just a report about where the measurements are, like between the dots.
Okay, I'm gonna allow state 63, which is a crime scene sketch accompanied with the raw data that allowed Detective Fall to create the sketch to accompany it. Those are the measurements that were made. So 63 will go back. We have rescued Mr. Jarvis's notes from that pile, and they're now in the excluded zone. Anything else from Mr. Manettis about what goes back with the jury?
Not this time, Judge.
Oh, well, we're not leaving, so, till we do, so keep looking at it. All right,
Judge, I've looked at 3A again, and I don't have an issue with going back.
all right, so you're withdrawing your request for redactions to states 3A?
Yes.
Okay, and can I assume you've left the exhibits in numerical order while you're doing? Good.
I'm just getting ready to add 3A back.
Great.
We got put 63 back.
Now, I have a question over here. It's what is the video system like with jurors? Like, are they gonna be able to manipulate it? Okay, we have it for.
No, they can start and stop it, but they'll be using Windows Movie Player or whatever plays those videos.
Scroll, they can like scroll.
Correct, start and stop, replay, which is the value. So they could stop and have a discussion, which they can't do while we're all seated here. But it's not a Macintosh, and all they have is a keyboard to mess with it. So start, stop, rewind, like that.
I guess you could tell them that, because I think there are shortcut keys to do that stuff.
You know what, the tech savvy jurors figure that out.
Right, Judge. And they don't have their phones over.
Correct.
So they might.
They don't have their phones while they're in there.
Or you can just, or where is it here?
And I think was 196A states exhibit. Aaron, I thought this might be a demonstrative.
That's the neck photo, and it was described as a demonstrative. It doesn't mean it can't go back. That's really up to you all. If you want to object and you want to tell me why you don't think it should go back. I won't make you explain why you possibly care in this case, but that doesn't mean you shouldn't object.
Yeah, I'm just kind of was an impulse looking at it.
Can you guys come on?
Oh, yeah, I just said, yeah, I said it's just an impulse because it's not a picture of the guy, it is like an illustration of.
Right. It doesn't go back if you object. That's you control that.
Okay, I don't object.
Mr. Rowe, any objection to 196A, the demonstrative of the human throat?
No.
All right, it'll go back. And what about 1A in case the jurors ask? That's the blow up of the map in case they want to have a big version. Mr. Rowe, any objection to that going back? The photo itself is already in a small version.
No, if that'll help,
I appreciate that approach. Mr. Manettis, any objection to 1A, the blow up of states 1 going back?
Can I see it, Judge?
See it, you've seen it like 1,000 times.
Yeah, that's fine.
Okay, good.
Your Honor, I reviewed the rest and I don't have any more objections.
Okay, so then what I will get whenever we reconvene will be a thumb drive from Ms. Porter that has the 2 audio files, all the video files we've discussed. I have Mr. Menetes's video file. I'll get that on the jury's machine and we should be good to go. Last call, Mr. Griner, anything else from the state?
No, Your Honor, nothing.
Mr. Menetes, anything on behalf of Mr. Phillips?
No, Your Honor.
Okay, Mr. Rowe?
No, yes.
All right, we'll be responsible, obviously, for getting your clients over here on Friday if we are operating on Friday. Again, the assumption is we are operating. I'll let you know if we aren't. I'll probably confirm that we are anyway, but silence means be here by 9 on Friday. Everyone stay dry. Thank you. I do. Oh, yeah. One last thing before you all go. There were 40 jury cards submitted. Not all questions were asked, but every card submitted by the jury will be made into a composite courts exhibit 1. So the record will have all 40 cards submitted by the jurors, and I'll get that to Ms. Rivers. Thank you.